Yes, addition. Similar.
Pardon to make a mention, Your Lordship. Lordship, yesterday in item 23, in a batch of writ appeal, Senior Counsel Mr. Sahoo was appearing. Your Lordship directed us to file a list of citation, Your Lordship. It may be taken on record, Your Lordship. Let us see this. Take down one citation. Take down. Reading that is Saraswati versus Saraswati, 2016, Volume 2 ILR. Justice Vinith Saran, Justice B.R. Sadangi.
Page.
Page. Basically, it has been discussed about that. Where it appeal would be maintained about the college. Yes.
Pardon for my mention, Manu. One petition regarding land acquisition matter for final disposal hearing, and one petition for withdrawal.
Beg your pardon. This is 24046 of 2022. It is pending for admission, and I also submitted it.
Yes. Content matter.
Supplementary list, item number 1.
Applicant was directed to furnish the was to ascertain the date when the representation was communicated to the opposite party. And this is the order dated 10 to 2020.
None of these are
None of
postal restrict filing.
Could of this matter after. Yes.
Item 2.
Last get Honorable Court directed to take instruction
Regarding the status of the representation, can I have some more time? 10 days. Item number 2 to 5.
Counsel for the.
No, item number 4, my lord, has service.
We are going one by one. Item number 2, you want 2 each time. Land counsel for the state, 6-2 is for the time to obtain instruction. Terms of the order dated 5 to 2025. Put of this matter. 10th March 2025. What about number 3? Same thing.
That's a fresh. That is a fresh one.
No, it was listed.
No, 3 is listed earlier. 4 is fresh.
4 is fresh.
10/3/2025. 4.
No, they are there is something.
4:30.
Let us see the order.
My lord. Non-implementation. Order that is 20.
So it will come. Let us say 24th of March 2025. Yes.
5 you want more time.
24.
So same. 5 item number 2, 3 is order agency 10/3/2025.
And item number 22, my lord, I have filed withdrawal memo permitted, may be permitted. 23.
खाली गोटे लाइन लिख दो माने कौन पे फाइल लिखी तापर
item number 23. Withdrawal memo file. Let's see the contemplation type thing for this. Then withdrawal memo is accepted, disposed of the withdrawn.
Item 6.
May applicable. Second round of approach before the election.
What is your first?
First order Annex 5, 26. Starts from page 26. The order is at page 28.
Yes.
And matter relates to repurchase of land belonging to the Sri Jagannath temple. Because I have my vendor purchased in 1964, my mother purchased in 1986. Thereafter, a demand was made for 47 lakhs. I applied that it should be reduced because as per the uniform policy, the amount will not be that much. This court directed in my first round, paragraph 4, my lord, the order, page 28.
Yes.
Keeping in view the submission made, the averment taken in the writ petition and the documents being gone through, we find that after receipt of the letter dated 10/5/19 indicating the consideration amount determined for purpose of said consideration amount, stating therein that said fixation of consideration was contrary to the uniform policy, and on higher side, especially without taking into account the long-standing possession of the petitioner in respect of such a small piece of land, that too not as the first purchaser but as a purchaser subsequent thereto. It is submitted by Lord Counsel for the petitioner that despite the return made by the petitioner on Annex 5, as yet no further decision has been taken by the appeal part number 3. In the above state of affairs, at this stage, we are inclined to dispose of the writ petition with the observation that in the event the petitioner files face representation for consideration of his grievance as to the fixation of consideration within 2 weeks ends, the opposite part number 2 would do well to consider the same and dispose of it in accordance with law at an early date and intimate the result of the same to the petitioner within a week thereafter.
Yes.
Then Annex 6, I submitted the representation.
What amount will be the increment?
Mm. Was not considered. That is why perhaps that might have lost or something like that. They asked the petitioner to file a fresh representation. That is the.
That is all right.
And case of the order of this court, you file the fresh representation.
Yes, madam.
That is Annexure 6.
At page 30. Yes, madam.
What order was passed?
Order was passed. You let me kindly come to page 34.
Yeah.
Paragraph 3, madam. This is how the consideration money amounting to rupees 47,51,000 has been fixed after following all the procedures as per provisions of uniform policy, and the temple managing committee meeting held on 15/2/21 also rejected the proposal of reduction of consideration money. They said it is rejected since 21, there is no scope of reconsideration, even if as per the observations of this court. And paragraph 5 of my representation, you may kindly see, I have taken specific case that even if according to the uniform policy, my valuation will be less because I am in possession.
No, Mr. Raw, suppose they have fixed that this should be the amount of the land. You say that as per the policy decision, this should be at a lesser side.
Yes.
So how in a writ petition you will adjudicate that what would be the value, and if you are disputing that amount, then you are to take recourse to the appropriate remedy. In a writ petition, how can we determine that this is the higher side?
But my humble submission.
Unless, of course, it is against their own.
Yes, if
Yes,
that is এই ଏରିଆର ଆମେ ଏଇ ଜମି ଗୁଡାକ ଏଇ ରେଟ୍ ସେମିତି ଗୋଟେ admission ଥିଲେ ତାଙ୍କୁ କହିବ, otherwise କେମିତି?
Again, clause 4 of the, I have taken an averment specifically in the same vicinity. 2 registered sale deeds have been executed. But
so you see, ଆପଣଙ୍କୁ ସେ ଯୋଉ କହୁଛନ୍ତି ନା ସେ sale deed, ସେ sale produce କରିବା ଦରକାର appropriate court ରେ। ଆଜ୍ଞା ଦେଖନ୍ତୁ ସେଇ ଏରିଆର ଏଇଟା ତାକୁ adjacent land, ସେଇଠି ଗୋଟେ sale deed ହେଇଛି, ଏଗୁଡାକ ରିଟ୍ ରେ କେମିତି ଆମେ?
uniform policy page 22 ଟିକେ ଦେଖନ୍ତୁ, I have annexed that uniform policy.
କଣ ଆସୁନାହିଁ?
Clause 4.
ହଁ,
ବାସଗୃହ ନିର୍ମାଣ କରି ଭୋଗ ଦଖଲ କରି ରହୁଥିବା ବ୍ୟକ୍ତି ବିଶେଷଙ୍କୁ ସମ୍ପୃକ୍ତ ଜମି ବିକ୍ରି ନିମନ୍ତେ ନିମ୍ନମତେ ଜମିର ମୂଲ୍ୟ ନିର୍ଦ୍ଧାରଣ କରାଯିବ।
Yes.
30 ବର୍ଷ କିମ୍ବା ତଦୁର୍ଦ୍ଧ୍ୱ ସମୟ ପାଇଁ ଉପଯୁକ୍ତ ପ୍ରମାଣ ସହ ଦଖଲରେ ଥିଲେ ଜମିର ସ୍ଥିରକୃତ ବଜାର ମୂଲ୍ୟର 10 ଭାଗ। I come in this category. So they have applied the uniform.
No. ଆଗରୁ ସେମାନେ ଗୋଟେ ରେଟ୍ ଫିକ୍ସ କରିଦେଇଛନ୍ତି।
ଆଜ୍ଞା।
ଏଇ ଯୋଉ ଆପଣ କହୁଛନ୍ତି ନା 47,51,500 ଯୋଉଟା କି ବର୍ତ୍ତମାନ କନଫର୍ମ କଲେ, ତ ଆପଣ ସବଷ୍ଟାନ୍ସିଏଟ କରିବାକୁ ପଡିବ ସେଇ ଯୋଉ 47,51,141 ଟଙ୍କାଟା କଲେ, that goes against the policy decision which they have
Yes, madam. That is what he has not reconsidered.
ନା ରିକନସିଡର ନାହିଁ, ପ୍ରୋଭାଇଡ ଆଗରୁ ଭୁଲ ହେଇଥିବ ତାହେଲେ ରିକନସିଡର କରିବେ।
ଆଗରୁ ସିଏ ତ କହୁଛନ୍ତି ଆମର ଆଗରୁ ଯୋଉଟା କରିଥିଲୁ ସେଟା ଠିକ ହେଇଛି, ପଲିସି ଅନୁଯାୟୀ ହେଇଛି, ବର୍ତ୍ତମାନ ଆମେ କେମିତି କଣ ତାକୁ କରିବୁ?
ଖାଲି ପଲିସି ଅନୁଯାୟୀ ହେଇନଥିବ ତାହେଲେ ଭୁଲ। ଯଦି ପଲିସି ଅନୁଯାୟୀ ହେଇନି,
again
so that he has to show us.
Yes, that is what, my lord. 05 decimals of land.
No, ଆପଣ ଯୋଉ ଆମକୁ ଚାର୍ଟ ପଢିଲେ
ଆଜ୍ଞା
10%,
ଆଜ୍ଞା
10% ତ
10%। ଆଉ ମୋ ଭେଣ୍ଡରର ଯଦି ପଜେସନ ନିଆଯିବ ତାହେଲେ ଇଟ୍ ଇଜ ମୋର ଦ୍ୟାନ୍ 30 years।
ହଁ ସେଇଟା
ନହେଲେ ମୋର ପଜେସନ ହେଲେ ବି 12 ରୁ 20 ଭିତରେ ମୁଁ ଆସିବି। ନେକ୍ସଟ କ୍ଲଜ 47 ଲକ୍ଷ 5 ଡିସିମିଲ କହିବା ମାନେ
that is
5
different.
କୋଟି ଟଙ୍କା ହେଲାଣି।
That is different. କେତେ ହେଲା କଣ ହେଲା, but if they have not followed their procedure, you have a case. Otherwise ଆମେ କାଇଁ ପଛକୁ ଭିତରେ।
Well, that is what the previous writ petition.
ଠିକ ଅଛି।
He should have.
Previous writ petition, there is nothing. They will only ask to consider.
Previous writ petition of
after this, my taking into account my possession.
ନା but ସେଇଟା first day it has been disposed of, ସେଗୁଡା କଣ ହବ? They have to do it in accordance with law.
এই কেসରେ নোଟିস ଗଲେ ସେମାନେ justify କରନ୍ତୁ, because I cannot justify it.
But you are to prima facie bring material before us that this amount which has been fixed earlier, 47 lakhs so and so, so that was prima facie not in accordance with the policy decision which you have taken. At least ସେତିକି ନ ଆଣିଲେ, କିଛି material ନ ଆଣିଲେ କେମିତି ନୋଟିସ୍ ଇସ୍ୟୁ ହବ, ଇଏ ସେ ଆଡଜୁଡିକେଟ କେମିତି ହବ ସେ ଜିନିଷ? ଆପଣ ଯୋଉ କହୁଛନ୍ତି ନା ସେ ଏରିଆର ତା ପାଖାପାଖି ଜମିରେ ଏଇଆ ଭ୍ୟାଲୁଏସନ ହେଇଥିଲା, these are all subject matter evidence.
All right, man, I will supply those documents. I have taken an averment. I have given the reference of those sale deeds. But
the land and counsel for the writ petition has been filed by the petitioner Vijay Kumar Das for quashing the order dated, the notice dated 10/5/2019 of key notice dated opposite party number 2. Opposite party number 2. Consideration money amounting to rupees 47,51,141 for finalization of the land sale case and for execution of the registered sale deed after grant of permission under section 16(2) of Sri Jagannath Act 1955. The learning counsel for the sub-paragraph petitioner submitted that when the petitioner earlier approached this court in WPC number 21058 of 2024, questioning the consideration amount determined by the opposite party number 2 for alienation of the land in question in favor of the petitioner within the framework of uniform policy, this court the petition had order dated 24/9/2024 with observation that in case the petitioner files press representation for consideration of his grievance as to the fixation of the consideration, the same shall be disposed of by the opposite party number 2 in accordance with law. Mr. Mishral and counsel for the petitioners submitted that in terms of the order dated 24/9/2024, the petitioner submitted a phrase representation dated 8/11/2024 before the opposite party number, and in a mechanical manner, the representation has been disposed of without keeping in view the uniform policy as has been annexed to the writ petition as annexure 2. The land counsel for the petitioner submits that there are documentary evidence available with him to show that in the very same area, the persons purchased the land at a lesser amount in consonance with the policy, the uniform policy decision. Therefore, the fixation of the amount at rupees 47,51,141 is at a higher side. It seeks some time to produce the document, file the documents, put up this matter favorably.
Next, please.
With this matter.
Okay. 2 weeks. Next week.
File with an affidavit.
2 weeks time.
Because one thing, आपको केते गुडे जिंस करिया पड़ो आपण मन करो आपनकर गोटे पर्टिकुलर प्लॉट अछि ना आपण जो कहउछन्ती एडजेसेंट प्लॉट रो तो एडजेसेंट प्लॉट में आपको मैप टाणिया पड़ो से मैप रो एती जमी तार सेल डीड तार ए बे बिक्री हला बहुत जिंस दरकार
सेही साई रो कुंडेइमेंट साई रो
हां से
ସେଇଟା ଯେ ଆମେ ତ ଜାଣିନୁ ସେ କଣ
आगे
नो तो
आगे मु आई गिव डिटेल्स
प्रेजेंट मार्केट
खाली गोटे से जो से रिप्रेजेंटेशन डेट टा 7/10/24
8/11 नुहे
8/11 रे सी पुट अप कले ताको ऑफिस रे मोर 7/10 रे रिसीव
आपनकर इंडेक्स रे लिखाई जी रिप्रेजेंटेशन डेटेड 8/11/2024 that is 7/10 पर्यंत
आका से
7/10
टाइम मते दे
all right 7/10/2024 जोटा annexure 6 जोटा कहूना रिप्रेजेंटेशन दले फिक्स फ्रेश रिप्रेजेंटेशन द डेट होची 7/10/2024 है ना all right
what a present market value
yes 10
7.
That's useful. Lecture 1, page 13 is the notice informing the petitioner that for land amounting 84055 decimal is to be acquired, and she was directed to appear before the authority on 22/4/2022. You also get that page 13.
yes that we have
And
seen.
lecture 1.
Yeah.
But the person to that, she appeared and she was told that the compensation amount of the land has been fixed at 5 lakhs amount. Thereafter, my lord, she applied for the benchmark valuation. You'll also get at page 14, annexure 2. The benchmark valuation of particular village is 1,59,72,000 per acre. Thereafter, my lord, on the annexure 3, she submitted a representation before the authority was passed the award for reference to the competent authority for determination of the amount, but that has not been considered till date. Rather, after receipt of that annexure 3, again she was issued with a notice, annexure 4, that the valuation is 4,15,000. It should be.
So when the prayer was made for reference to the authority for determination, so it should have been done 64 रे ସେମାନେ ଆସିଛନ୍ତି ଆପଣ ପୁଣି ତାଙ୍କୁ ନୋଟିସ୍ କରି ଏତିକି ଟଙ୍କା ନେଇଯାଆନ୍ତୁ କଣ was not satisfied. He has the documents with him that you have fixed a benchmark valuation, and that is why on that basis he is claiming higher compensation amount. So 64 रे तो रेफर करिवे आपण कोन पुनी गोटे नोटिस कोन पठे देले अति नै जाओ तो लेखम नोटिस करिया
Instruction नहीं है जल्दी वो 80-year-old lady ने instruction दे सब
aja you take instruction why whether he has referred because I don't know
80-year-old lady so
aja 31/5/2022 ରୁ ସେ petition ଦେଲେଣି for referring the matter and we are in 2025 it has not been referred. Your collector is doing this. So take instruction whether it has been referred or not. His instruction that is it has not been referred, rather he was served with a notice. The writ petition has been filed by the petitioner Indu Mahanti, which is at about 8 years, with a prayer for a direction to the opposite party number. Refer की करिवो collector.
She has made application with the opposite party number 3 man.
ଜାଗାଟା କାହାର?
Jagata petitioner. Notice in the notice her name is there.
Name is there but ଆଉ କାର ନାଁ ଅଛି ସେଟାରେ recorded.
Durga Charan Mahanti and
and
Indu Mahanti.
କୋଉଠି?
Page 30 ରେ ଅଛି annex 4 ରେ ବି ଅଛି.
Right. So
But representation is made to Mandala Adhikari Subarnarekha Johnson. The receipt. Mandala.
before whom you find this 64
Ballot the opposite party number 4 she has made the application. Before the opposite party number
ମଣ୍ଡଳ ଅଧିକାରଟା କିଏ?
who has issued the notice and who has also determined the compensation.
64 ର ଏଟା ଫାଇଲ ହବ ପଡେ
Collector.
Collector is the competent.
64 collector is the
ତାହେଲେ ଆପଣ ଆକୁ ଦେଲେ ଯେ
ଆକୁ ଦେଲେ ହବ
64 ଲେଖିକି ଦେଇଛ
ଯାର ଅଥରିଟି ନାହିଁ ସେ ରେଫର କଣ କରିବ?
the authority can send it to the collector for reference.
କଣ ପାଇଁ?
If while she has not filed the application.
Clear ଅଛି any person interested
Directly
who has not accepted the award may written application to the collector require that the matter be referred by the collector to the determination of the authority.
So notice
Language is very clear.
What is wrong in asking you to take the money because you have not taken?
You are to file the application before the collector, and but this application indicates that it is filed before the authority who is not competent to refer. How will you refer the matter? ଆପଣ କହୁଛନ୍ତି ସିଏ ପଠେଇ ଦେଇଥାନ୍ତେ କଲେକ୍ଟରଙ୍କୁ କଲେକ୍ଟର ଇ କରିଥାନ୍ତେ. This is not the way.
Take what action has been taken.
You will take instruction. What you will do?
No
action has been taken. You have to take the money.
On that
No
application.
action can be taken.
Rightly or wrongly she has made an application.
So rightly you have been asked your पैसा ନେଇକି ଯାଆନ୍ତୁ.
ତା ପାଖରେ ସିନା ଜଣଙ୍କ ପାଖରେ ଯଦି statute ତାଙ୍କୁ authorization ଦଉନି to refer the matter, how can ଆପଣ ହାଇକୋର୍ଟ ରେ ଆସି application ଦେବେ ଯେ ମୋ matter ଟାକୁ refer କରିଦିଅନ୍ତୁ? Can we do that? So when the prescribed authority is there, so any application is to be made to the
collector.
That you have not done. So better you withdraw this petition, file a petition or application before the appropriate authority, making appropriate prayer so that reference can be made. This is not in consonance with. Or if you say we can keep it next week, you may take instruction. कारण एटा 22 मसियार हुएतो से आ भितरे आउट किछि कोन जदि परिथिबे कलेक्टर को एप्लीकेशन देथिबे कोन हेतु एटा जब कोन कोन लिखले कि पूरा opposite party number 3 to refer the matter for determination of the authority regarding the amount of compensation to be paid to the petitioner. However, it appears from Annexure 3 that the petitioner has been addressed to the zonal officer from Land Acquisition Officer, Subarnarekha Irrigation Project, Baripada Zone. We made a specific query from the Land Council for the petitioner as to whether, in terms of Section 64 of 2013 Act, any written application has been made to the opposite party number 3, Collector Moyurvanj, for making the reference to the authority or not. The Land Council for the petitioner seeks some time to obtain instruction, put up this matter in the week commencing from 3rd of March 2025.
Item 8.
Correct.
3 months. Three months টা কাটতে দেবে
কাটি দেবি
ସେ ଟାଇମ ଦଉନାହାନ୍ତି 3 months ରହିଲା ବେଳକୁ ଜମା ଟାଇମ ଦଉନାହାନ୍ତି
ଆଉ ଟିକେ ଅଧିକା ଟାଇମ ଦବା
ନାଇଁ ନାଇଁ ସେ ପ୍ରିଫରେବଲ ଯୋଉଟା ଅଛି
ଦବା ନା କିଛି
ନାଇଁ, ନାଇଁ।
expeditious ନାହିଁ?
As expeditiously as
As
possible.
ଭଲ କଥାଟେ, ଭଲ କଥାଟେ।
अरे movement the
ମାନେ
prayer
ଇଏ ବି ହଇରାଣ ସିଏ ବି ହଇରାଣ କଣ କହିଲେ
prayer में can do that.
ରେୟାର ଡିସପୋଜାଲ ଅଫ ରିପ୍ରେଜେଣ୍ଟେସନ ଥିବ ଆଉ କଣ?
No.
Nahi.
There's something. Review the order of the past by the ordinance. Which was dismissed.
ସେଇ ଗୋଟାକ
नहीं. Another para 10 में can do class.
ସେଇ ରିକଲ
अरे
ଦେଖିଦବା
and the efficacious remedy is there. The CMA rejected. When the dismissed, then CMA filed para 10. It has dismissed on 25. Instead of approaching appropriate forum, how can this?
ମୁଁ ମେନ୍ ଆପ୍ଲିକେସନ ଟାକୁ
No, I am not on that. The CMA rejected, then appropriate forum authority.
Which paragraph you are showing?
Prayer then annexure to be cut aside. So prayer to review. Para 10
that is the order of the civil judge.
Against that order, the CMA was trying to recall that order. The CMA dismissed on merit. Against that, the appropriate CMP is available.
ମୁଁ ସେଇଟାକୁ ଚ୍ୟାଲେଞ୍ଜ କରୁନି ମୁଁ ମେନ୍ ପିଟିସନ ଟାକୁ ଚ୍ୟାଲେଞ୍ଜ
How can the main what's your foundation?
Similar order passing.
Similar order bill ରେ pass ହେଇଯିବ ତ ସିଭିଲ ଜଜ୍ ଅର୍ଡର କରିଛନ୍ତି ଆମେ କଣ ଡିସପୋଜାଲ ଅଫ ରିପ୍ରେଜେଣ୍ଟେସନ କରିବୁ
ମୁଁ ମେନ୍ ଅର୍ଡର ଟାକୁ ସିମିଲାର ଅର୍ଡର
କେମିତି ହବ
Filed by the petitioner to recall the order. No notice and notice
not frustrated without anything
they have to use the convention delay. Here are the days that the infant order is sponsor is not sustainable in the IFR and they have to send it set aside. Consequently, the order declared concept of the sponsor is recalled. The petitioner shall appear before the land civil judge, senior division on such answers that and the matters to be decided in accordance with law. The court shall make every endeavor. Representation disclosure of
No.
says that competent.
They are to review the order.
so we have reviewed it we have set aside that order ସେ ଯୋଉଟା ମାଗୁନାହାନ୍ତି we have allowed the writ petition without notice.
The order sheet which was relied upon by the Land Council for the petitioner that shows that at no point of time notice was issued to the petitioner. Here he must have also given that.
Para 10 for me. Your lordship may pass that. Para 10 may can do.
Para 10 what? Para 10.
Against that order, CMA was filed.
ଆମେ ସେଇଟା ବି set aside କରୁଛୁ ପରା because on the ground of delay it has been dismissed.
That was never under challenge.
ଚ୍ୟାଲେଞ୍ଜ ମୁଁ କରିନି, ମୁଁ ମେନ୍ ଅର୍ଡରଟାକୁ ଚ୍ୟାଲେଞ୍ଜ କରିଛି।
ଚ୍ୟାଲେଞ୍ଜ କରିନାହାନ୍ତି ସେ ଅର୍ଡରଟା?
ନା
ଏ
ସେଇଟା ସେ ଅର୍ଡରଟା ସେ ଦେଇନାହାନ୍ତି।
ଆଚ୍ଛା,
ଅର୍ଡରଟା
ତ
ଆସି
ଯୋଉ ଅର୍ଡରଟା ଆପଣଙ୍କ ପାଖେ ନଥିବ ତ ସେଟାକୁ ଆପଣ ଚ୍ୟାଲେଞ୍ଜ କରିବେନି।
ନା ମୁଁ ଲେଖିଛି ଆଭରମେଣ୍ଟ ନେଇଛି, ସେ ଅର୍ଡରଟା ଦେଇନାହାନ୍ତି। ସିଏ 7
ସେଇଆ ତ କହୁଛି, ଯୋଉ ସପୋଜ
ମୁଁ ମେନ୍ ଅର୍ଡରଟାକୁ ଚ୍ୟାଲେଞ୍ଜ କରିଛି। ମେନ୍ ଅର୍ଡର ସେ ମତେ ୱିଦାଉଟ୍ ଇସ୍ୟୁଇଂ ଏନି ନୋଟିସ ସେ ଡିସମିସ୍ କଲେ।
ତାପରେ
ଆପଣ ଚ୍ୟାଲେଞ୍ଜ କଲେ କଣ କହୁଛନ୍ତି?
ସିଏମଏ ଫାଇଲ କଲି, ସିଏମଏ ର ଅର୍ଡରଟା ସେ ଦେଇନାହାନ୍ତି।
ତ ସେଟା ଆଉ ଚ୍ୟାଲେଞ୍ଜ ହବନି, ସେଟା ରହିଲା।
ନାଇଁ ସେଇଟା ଲେଖିଛି,
ହଁ ଲେଖିଦେଲେ ତ ସେଇଟା ପଳେଇଲା ଆଉ।
ଦେଖିଲି
But
ମେନ୍
you
ଅର୍ଡର
have to file, not only you have to challenge that order in the prayer portion, but you are supposed to file that order also.
ଅର୍ଡରଟା ସାର୍ ସେ ଦେଇନାହାନ୍ତି।
ଯୋଉ order ଆପଣ ଏଇଟା ଯୋଉ ଦେଇଥିଲେ ଆଦେରେ all these things were there before us.
ହଁ
ବୁଝିଲେ ନା?
ନାଇଁ ଆଗରୁ ସବୁ ମେନ୍ ଅର୍ଡରଟାରେ ହେଇଗଲା।
ନାଇଁ ହେଇଗଲା ତ, ସେ ଗୋଟେ ହେଇଗଲା, ବାକି ଗୁଡା ସବୁ ସେମିତି ଧରା।
ସବୁଥିରେ ମୁଁ ସିଏମଏ ଫାଇଲ କରିନି, ଗୋଟାଏ ଦିଟାରେ ଫାଇଲ କରିଛି। ଏଥିରେ ଜମା 4ଟା ସିଏମଏ ଫାଇଲ ହେଇନି, ସେଇଥିପାଇଁ ମୁଁ ଆଉ ସେ ଅର୍ଡରଟା ରଖିଲି ଗୋଟେ କାଟେଗୋରୀରେ।
ହେ ଭଗବାନ।
ମେନ୍ ଅର୍ଡରଟାକୁ ଚ୍ୟାଲେଞ୍ଜ
Where is the, let us see that order sheet which we relied upon in this case.
ଗୋଟେ ମାଟର ସାର୍
ସେଇଟା
4126
ସେଟାରେ କହୁଛନ୍ତି ପରା ସିଏମଏ ନଥିଲା।
ହଁ ସେଇଥିରେ ସିଏମଏ ନାହିଁ, ଆଉ ଅନ୍ୟରେ ଯୋଉ ଅର୍ଡର ସିଟ୍ ସବୁ ଆଣିପାରିନି।
No, first you come to that 2692 of 2025.
269
2692 of 2025. Your prayer is to, what is your prayer? To set aside the order dated 6/2/23. Come to that.
6/2/23
Under
ସେଟା ହଉଛି
Annexure
ମେନ୍
2.
ଏଲଏ ଆପ୍ଲିକେସନ ର ଅର୍ଡରଟା।
Come to that order.
ଆଜ୍ଞା
You are saying High Court ଗୋଟେ writ petition file କଲେ, that was dismissed. When you filed a review, that was dismissed. Since you didn't get the order in the review, you approached the Supreme Court challenging the original order.
ନା ସେଇଟା ନୁହଁ, ମୁଁ ସେ ଅର୍ଡରଟା ଆଣିପାରିଲିନି ବୋଲି ମୁଁ ଏକାଥରେ ଫାଇଲ କରିଥିଲି, ଦେଇଦେଲି। ସେ ଅର୍ଡରଟା ବି ଅପଲୋଡ ସେ କରିନାହାନ୍ତି। ସେ
Please come to that order dated 6/2/23.
6/2/23
Yes. Annexure 2, which you are challenging in this writ petition. Please place that order.
Neither the petitioner nor his counsel is present today. No step is taken on his behalf either.
Yes.
The present land acquisition case is instituted basing upon reference application under Section 18 of the Land Acquisition Act by the petitioner and subsequently submitted to this court by L.A. Jagatsinghpur. This is a reference applied in the year 2004. Originally, this is a land acquisition case of the year 2002. Since then, till date, more than 18 years have been elapsed. The Honorable High Court is pressing hard to dispose of the year-old cases. On the other hand, the petitioner in this matter is not present in the court. No steps has also been taken on his behalf. Neither oral nor documentary evidence has also been adduced. There is no reason to defer the matter from the amount of compensation already awarded. କିନ୍ତୁ କୋଉଠି ନୋଟିସ ଦେଲେ ଗୋଟେ
You have come directly to this court or you filed any other application?
ଏଥିରେ ସିଏମଏ ଫାଇଲ କଲି।
Huh?
ଏଥିରେ ସିଏମଏ ଫାଇଲ ହେଇଛି, ସିଏମଏ ଟା ଡିସମିସ୍ ହେଇଛି 6/1/25।
ଶୁଣନ୍ତୁ ଆପଣ କେତେଟା ଅଛି ପେଟିସନ? ହାଉ ମେନି ପେଟିସନ୍ସ? ପଏଣ୍ଟ ଆଉଟ୍ କରନ୍ତୁ କୋଉଟାରେ ସିଏମଏ ଦେଇ ନାହାନ୍ତି।
ଏଥିରେ ମୁଁ ସେଇଥିରେ ଯୋଉ ଅର୍ଡରରେ ଲେଖିଦେଇଛି, ଯୋଉଗୁରାକ ସିଏମଏ ଦେଇନି ତା ଉପରେ ଅର୍ଡରଟାରେ ଲେଖିଦେଇଛି, ଯୋଉ ଜେରକ୍ସ ଗୁରାକରେ ଦେଇଛି।
ତାଙ୍କୁ ଗୋଟେ କପି ଦିଅନ୍ତୁ ସାର୍।
କୋଉଟାରେ?
ତାଙ୍କୁ ଗୋଟେ ଦିଅନ୍ତୁ।
ଏଇଟା
basing on your thing, order has to be passed so that
ଏ ଯୋଉ ମୁକେଶ୍ୱର ମହାଦେବ ସେଇଟାରେ ଫାଇଲ ହେଇନି।
Going here and there, madam, we are in the first item.
ଫାଷ୍ଟ ଆଇଟମ ଫାଇଲ ହେଇନି। First item ରେ
2692 ରେ ଆପଣ ଲେଖିଛନ୍ତି ଯେ against that order under annexure 2 you filed a CMA application
ହଁ CMA
and that was disposed of also on the 6th of 2025 on the ground of delay.
ସେ ଅର୍ଡର ଟା ସାର୍ ମୁଁ ଦେଇନି।
ନା କେବଳ ଦେଇନାହାନ୍ତି ଆପଣ ପ୍ରେୟାର ପୋର୍ସନ ରେ ମଧ୍ୟ ଲେଖିନାହାନ୍ତି ଯୋଉ ଚ୍ୟାଲେଞ୍ଜ କରିଛନ୍ତି
ସେଇଟା ଲେଖିନି। ମୁଁ ଯେହେତୁ ଏଇ ଯୋଉ 4ଟା 5ଟା ମାଟରେ ଆସିଲା ତ ଏକାଥରେ ଫାଇଲ କରିଦେଇଛି। ସରି ମେନ୍ ଅର୍ଡର ଟାକୁ ଲେଖିଦେଇଛି କାରଣ ଯୋଉଥିରେ ଯୋଉ ଏଲେ ପିଟିସନ ରେ ଗୋଟେ ବି ନୋଟିସ ନ ଦେଇକି ସେ ଡିସପୋଜ
ବୁଝିଲୁ that is right
ଏକା ଭଳିଆ ହେଇଥିଲା
but କିଛି ତ ଗୋଟେ one procedure ଟିକେ follow କରିବେ
ସେଇଟା ଗୋଟେ ଭୁଲ ହେଇଗଲା।
ତ କୋଉଟାରେ ଆପଣ ଫାଇଲ କରିଥିଲେ ମିସ୍ କେସ୍ ସେଗୁଡା ଟିକେ ନମ୍ବର ଗୁଡା ଦେଇ ମିଷ୍ଟର ମହାନ୍ତି have you marked କୋଉଟାରେ ଅଛି because she is saying କେତେରେ she has not filed at all.
एले के सी फाइल कर तापर स्टेप नेले he was
that मोर फास्ट केस टा जोथरे सार ऑर्डर टा अछि जोटा मु देइची सर
beneficial provision
4126 टा सर
if the council doesn't take steps
4126 टा सर देखिबो ना
2004 मसिया रु एले के सी फाइल कलेनी आपण 2023 पर्यंत केस चली पेंडिंग अछि तापरे से जो दिन डेट आपण टेक अप कले से दिन पिटिशनर नथिला हां तेनु ए ऑर्डर टा पास हे गला तो 19 इयर्स जदि जने लोक स्टेप नेला एवं गोटे पर्टिकुलर डेट रे ही वाज नॉट प्रेजेंट नहीं से दिन दे
ना जणा हेले भी इन द हाई कोर्ट आल्सो आपण गोटे कोन नॉन अपीयरेंस हेले वी आर आस्किंग जे जणा कर बिकॉज़ डिसमिस करके डिस्पोज कर देले केस टा फायदा कोन
सर गोटे मैटर 4126 टा के देखन 4126 रे से केबे नोटिस कले एसआर
गुडा छाडंतु आपण जोटा पचरा होची बिकॉज़ यू हैव नॉट फॉलोड द प्रोसीजर कोटा प्रोसीजर फॉलो करि नाहंती कहि दियंतु बाकी गुडा कैन कंसीडर
नहीं एमती भी जो सीएमए न फाइल करके भी गोटे दिटा डिस्पोज ऑफ हेज ମୁଁ ଲେଖିକି ଦେଇଦେବି
ଆଗ ଲିଷ୍ଟ ତାଙ୍କୁ ଦେବେ ସିଏ ବି ଭେରିଫାଇ କରିବେ
दासु
हां କାଲି
इज दिस मैटर टुमारो
କାଲି କରିବ ନା सोमवार କରିବ କାରଣ ଶୁକ୍ରବାର ପଳେଇଲେ କରେକ୍ସନ କରି ହବ
मंडे रखि दियो
ହେଲା ତାଙ୍କୁ ଗୋଟେ ଲିଷ୍ଟ ଦେବେ ଶୁଣ ଆଉ देयर इज नो डिसएग्रीमेंट
और सील फिर मार देली तब फेरी गई
ଭଲ କଲେ ଭଲ
तब फेरी दियो से देखि केम दे यस ने
आइटम 9
Over your ship's order.
କଣ ଗୋଟେ ଆଣିବାର ଥିଲା ବୋଧେ ଫରୱାର୍ଡ କହିଦେଲି
What happened here? Yesterday there was a batch of cases. This matter has been wrongly listed, so your ship segregated to yes. Your ship's order.
ଆର ଗୋଟାରେ ଡିଫରେଣ୍ଟ ଏଇଟା କଭର୍ଡ So where is that order in your favor?
Annexure 1.
ଘଟୁ ନାଇଁ ତ ଘଟୁ କୁଶ ଅଣ୍ଟୁ
आरो पिटिशन नाला नेपाल रे कोना
ये से मरिଯାଇଛୁ
की मर जाई
Nepal is the son of Ratho.
हां
That's no one in that judgment.
ଆଉ ତାର କିଏ ପିଲା ଛୁଆ କିଏ ନାହାନ୍ତି ଖାଲି you are the only legal heir
And that will be considered by the land action officer while disbursing the amount. We have to submit the legal heir certificate, death certificate. They will make inquiry in all.
you will not say how you are entitled to the land since we are disposing of your representation we need not say anything ଆପଣ ଗୋଟେ ଦେଲେ ଆମେ କହି ଦବୁ
have you mentioned
I mentioned
Who paragraph is
Your para 4.
সেটা তো পচারিବି সেটা তো ଖାଲି କହିବେ ଆଉ
The petitioner, father of the petitioner died. Petitioner being his LR pursuing the case, petitioner submitted also requested to take steps also.
being his LR. How many people have filed?
1.
LR is कौन? सुन लगे
True. It's on 1 in the reference case. Page 8, next one.
Relevant question, page 40.
Yes.
The property was jointly recorded in the name of the petition. And their name.
Ultimately, the RI will inquire the matter, he will submit.
Maybe.
If that man has died, then that man's legal
Is to be paid. Yes.
All will get. All will get. Yes.
Judgment is of 2019.
And see what, yeah. Correction. Pardon.
that is to be known because the petitioner or here the
Pardon.
ନିଜେ କରିଦଉଛନ୍ତି
Correction.
ନିଜ ଫ୍ୟାମିଲି ଦେଖିବ
Yes, no, what I understand.
then particularly that portion that needs to be dispersed the legal heirs of the
Yes, ma'am. Yes. I get.
Let's see the only
ठीक है.
they cannot be for us we are
Item 10.
Hey, please. Hello, the petitioner is one of the co-sharer in respect of the land at Annexure 1. That is plot number 1230 has been acquired for the purpose of construction of road in Bhubaneswar. Now, my lord, a suit is pending. Suit is pending since 2015. And now, my lord, I have made a representation to the collector that not Annexure 3 is notice to another person that now they're going to disburse the amount. So at any moment, then Annexure 3 must issue to another landowner. No, I am not agreed. I am just given an instance that they are going to disburse the, not I am. The ସେଥିରେ ଆମ ନାଁ ଆସିନି। ନା ଏଇଟା ବିପ୍ରଚରଣ ସେଠି ଆମେ ଗୋଟେ ଦେଖଉଛୁ ଯେ ସେ ମାନେ ଅଲଗା ଲ୍ୟାଣ୍ଡ ଓନର now they are going to ନା ଆସିନି ଯେହେତୁ ବର୍ତ୍ତମାନ ହଁ ଜାଗାଟା ହଁ ଚିନ୍ତାମଣି ସେଠି I am the granddaughter of Chintamani Sethi. I have given the genealogy. The Lords will get at
कि जो माने को ऐड करछे ऑपोजिट पार्टी नंबर 5 को आरंभ करी नहीं से माने समस्त होउछन्ती लीगल एयर्स
सूट रे समान सब पक्ष अछि
से माने को डिसाइड न हला पर्यंत हाउ इट इज टू बी and ultimately when the matter would be referred that who is to get the compensation
yes
share so the ultimately the authority means in the district judge he is to decide that who is to get what share.
Yes, that is exactly my case. My case, I have not. My price that is not that the my share be the amount in respect of my share be dispersed in my favor. My case is that since pending and the authority is going to disburse the.
No, once that is decided, then this suit becomes meaningless. Here, that authority or the district judge has all the powers to see that
yes,
who are entitled.
Yes, that is why my representation. That is why my representation.
What is your prayer in the representation?
My prayer is till the disposal of the suit, the compensation amount may not be disbursed in favor of
anyone. No, that is you are praying the other way. Rather, if you make a prayer for in the reference, the authority will decide.
Yes.
Not only you, but all the legal who will get what share.
Yes.
So in that way, he is to adjudicate that जो property टा अच्छी ता share रे कितने पड़ेगा. Then say on the compensation. Then once he decided, this becomes meaningless. This suit राव किसी रही बनी. Suit आपण file करिए only for that purpose.
If it will be referred to the authority, then it will undo. It has not been referred. That is. Exactly, he has not prayed that reference may be made. Yes. The amount disbursement hayni. So I have not given that.
Not been acquired. Huh?
Land has not been acquired.
What is the question of ଆପଣ ଯୋଉ anticipate କହୁଛନ୍ତି ନା
anticipate that notification is there. I have not filed that notification. ଆଜି ସକାଳେ ସେ ମୋତେ ଆସିଦେଲି
ବଢିଆ ଆମେ ଏମିତି ଫାଇଲ କରନ୍ତୁନି
ମାନେ ପର୍ସନାଲ ନୋଟିସ ହେଇନି
ଏଇ ଟାଇପ ର ଫାଇଲ କଲା କୋଉ ଟାଇପ ର ଆମେ ନଉଛୁ
ମାନେ ତାପରେ ଗୋଟେ ଭୁଲ ଫାଇଲ ହେଇଗଲା ପରେ ସେଇଟା ଦେଖେଇକି
ଗୋଟେ ଅର୍ଡର ହେଇଗଲା ପରେ ତାପରେ କଭର୍ଡ ମ୍ୟାଟର କରିକି
I'll bring to the
adjourning the matter. Land Council.
24 तारू आसुम मोटा फाइल कर देज भाई
Alright. It's,
ଏଇ ଫାଇଲ କରିଥିଲେ ସେମିତି ହବନି, ତାଙ୍କୁ ଆମେଣ୍ଡମେଣ୍ଟ କରି ଯୋଉଟା ସେମିତି ଫାଇଲ କରିଦେଲେ କେମିତି ହବ?
हमो application दे
you see, there is a limit to accept everything on good faith, but once good faith is otherwise taken, then
no that
we have to be
notification is there
Okay,
little more
okay,
careful.
ଦିଅନ୍ତୁ।
it was not
ଅଛି, unless you tell us how do we know?
yes yes
ଆଉ ତା ଛଡା ଯୋଉ representation
no that was
ଦେଇଛନ୍ତି,
not
representation ଟା ଯୋଉ ଦେଇଛନ୍ତି ମାନେ forever ତାକୁ କାହାକୁ ଦିଆ ହବନି? Your prayer is do not disperse.
that particular plot matter केवल 12 section
ଆପଣଙ୍କର ଜମି ଆକ୍ୱାର୍ଡ ଯାହା ଆଭରମେଣ୍ଟ ନେଇଛନ୍ତି ଏପର୍ଯ୍ୟନ୍ତ ଆକ୍ୱାର୍ଡ ହେଇନି, ତ ଆପଣ ପ୍ରେୟାର
ମାନେ ମୁଁ
କରିଛନ୍ତି ଯେ ମୋର ଯେପର୍ଯ୍ୟନ୍ତ ଇଏ ନ ହେଇଛି ଆଉ
no
କାହାକୁ
but I have taken the affidavit that it has been acquired but the notification was not available
Alright, next
2023 notification that is the dual also same
With application documents.
the land council for the petitioner pays for an adjournment to file some documents and if necessary to file an interim application for amending the writ petition. Which adjourn? Yes. Adjourn.
24 now ଟିକେ
मैं 24 में कर दूं काली फाइल
24.
12 also same as another process
12 already. 12 version.
Item 11.
The land in question, my lord, Isamo is Khasmahal. As per the amendment of OGLX Act, the lands, my lord, Khasmahal, Nodul, Ramakantha, and Nonavadi will be settled. They settle with the person who is in possession 3 years before the notification.
3 years or 5 years?
3 years.
3 years.
ଆଜ୍ଞା ସେଟା ଆସିଲା 2009 ରେ ତାପରେ ଏକ୍ସଟେଣ୍ଡ ହେଇ ଚାଲିଛି on that file an application before the Tahsildar. After your lordship will kindly see annexure page 52 my lord. The Tahsildar has recommended for settlement. After it was recommended, the sub-collector reminded the matter that some of the documents is required and the matter is still in that stage.
Where it is pending now?
Sub Tahsildar and the query which was made my lord.
If I'm not taken, the Tahsildar has to recommend to the collector to take
ନାଇଁ
decision.
ନାଇଁ ସବ୍ କଲେକ୍ଟର ଯିବ ସବ୍ କଲେକ୍ଟର କଲା ପରେ କନଫର୍ମେସନ ପାଇଁ କଲେକ୍ଟର
ହଁ ସେଇଆ କହୁଛି। So ତହସିଲଦାର କରିକି ତାପରେ confirmation by the collector.
ତହସିଲଦାର କରିକି ପଠେଇବ ସବ୍ କଲେକ୍ଟର ପାଖକୁ ସବ୍ କଲେକ୍ଟର thereafter recommend the case to the collector for confirmation.
So that it has not been sent. sub collector once ଯାଇଥିଲା ସେ ତଳକୁ ପଠେଇଦେଲେ
ଯୋଉ ଦେଇଛନ୍ତି ଆଜ୍ଞା ଏଇଟା ଜଳାଶୟ ହବ କି ନାହିଁ ଏଇଟା OGLS Act ନାହିଁ if it is used for homestay.
No, that we are not going into the merits. They will decide. Jalasayata, unless it is converted, can it be settled in your.
My lord, if it is used as a homestead, that is the language.
So,
merit ko to
we are not going to the merits. So what do you want?
My lord,
Tahsildar has to dispose of it. Take on this annexure 8.
In terms of annexure 8.
In terms of annexure 8.
And let them take instruction what the Tahsildar has done from 2007 till date.
ସେଟା ତ ଥିଲା 2017 ରେ compliance of objection. ଆପଣ କଣ ଶୋଇ ପଡିଲେ?
ଆଜ୍ଞା
2017 ହେଲାଣି we are in
17 ରୁ ତହସିଲଦାର ପାଖକୁ ଆସିଛି ସେ ତହସିଲଦାର
ଅର୍ଡର ସିଟ୍ ଗୋଟେ ଥିବ କିଛି ହେଇନି
କିଛି ନାହିଁ
ଦେଖିବ the writ petition has been filed by the petitioner S.K.Sahoo with a prayer for a direction to the opposite party to change the nature of the land from leasehold to freehold and to settle the same in favor of the petitioner. Referring to annexure 8 for compliance of the objection and thereafter to resubmit the case record for necessary action. It is argued that even though such a letter was issued way back in 2017, but no action has been taken by the Tahsildar. till date. Let the land council for the state obtain instruction from the Tahsildar Sadar Patak, that is opposite party number 5, regarding the status of the KLC number so and so, which were returned to him for compliance of the objection. Matter to be listed on 10th of March 2020.
ये लॉसिप में मतलब ये केस केएलसी नंबर 1886 मोर नुह खाली 109
କହିଲୁ ପରା 109 ରେ ଆସିବ
ଆଜ୍ଞା
ନାଇଁ ନାଇଁ ଲେଟର ରେ ଦିଟା ମେନସନ ହେଇଛି ସେଟା କୁହାହେଲା
ଏଇ ଯୋଉ ଇଏଟା ଆଣିବେ KLC ନମ୍ବର 109 ଲାଷ୍ଟ ଯୋଉଟା ପରେ ଏଇଟା ଲେଖିଦେବେ, ଲେଟର ରେ ଦିଟା ମେନସନ ହେଇଛି କିନ୍ତୁ ଆଗର ହଉଛି KLC ନମ୍ବର 109 ହେଲା। 10 ତାରିଖ ରହିଲା
ଆଜ୍ଞା
yes
13 Challenging the order 39/2020 passed in section 3G5 of the NH Act. My lord senior has stated that whether appeal will lie or relief will lie.
देखिए that's not all it
3G5
arbitration appeal case number
appeal ଲେଖା ହେଇଛି କିନ୍ତୁ appeal ଲେଖା ହେଇଛି
ଦେଖିଦବା
3G6 5 ରେ arbitration all cases are
3G5
5 ରେ order pass ହେଇଛି, then 6 will be governed.
6 is the Arbitration and Conciliation Act.
wait 3G5 is the amount is determined, the complaint of so is not acceptable to either of the parties. The amounts are on the application by either of the parties be determined by the arbitrator to be appointed by government. So that has been done
By the collector.
by the collector. Obviously, he is the arbitrator. Now,
6 months.
subject to the so and so are applied to the evidence. The competent authority so and so. What is the appeal provision and counsel?
In this manner provision there is no appeal. But so if Arbitration Act will be applicable manner, there is provision of appeal.
ଆପଣ ଗୋଟେ appeal file କରିଛନ୍ତି ପରା
ନା ଏଇଟା ଅଫିସିଆଲ ଲେଖିଛନ୍ତି
Actually, it is a wrong.
actually appeal ନୁହଁ
Arbitration
grant time I will
ସେଟା ଆଗରୁ କହୁନାହାନ୍ତି ବୁଝିବେ ଆମେ ଏତେ ଭିତରେ ପଶିବୁ
ସେଇଟା ଇସ୍ୟୁଟା
All right. The petition has been filed by petitioner Ramesh Chandra Misra for setting aside the order dated 39/2024 passed by the collector cum district magistrate Nayagarh in arbitration appeal number 8 of 2023, which arises out of LA case number 11/2021/80/2022. On an application under section 3G5 of NH Act. PG5 of NH Act reads as follows. Quote कर दो. PG6 states as follows. Quote कर दो this one.
arbitration
The land council for the state raised a preliminary objection that against the impugned order dated 13/9/2024, an appeal will be maintainable. And the land council for the under section 34 na
ସେଟା କି state କହିଲେ ନା କଣ
se function
ସିଏ କହୁଛନ୍ତି ନା ଇଏ କହୁଛନ୍ତି କିଏ କହୁଛନ୍ତି
state from state section 34 under section 34 of the 1996
Arbitration and Conciliation.
Arbitration and Conciliation Act. Land Counsel
That's
for
the
the
application for
petition.
setting aside, not appeal. Appeal.
Uh,
34 challenging
hmm.
if dissatisfied on 34 then appeal. 34 application for setting aside the award.
Hmm.
That
This is passed in by the arbitrator.
That is on the NHA Act.
Yes.
So NHA Act provides subsection 6 provides
Yes.
that the arbitration conciliation.
This should be applicable.
So we will not write the word appeal.
Appeal.
Appeal only can be challenged.
It can be challenged.
Subject to challenge. Section 34.
Appeal
34 district judge, na?
District judge.
under section 34 of the Arbitration and Conciliation Act 1996.
Depending on the
Availability of
availability and yet abhi bata.
Notification.
No.
Amount. Arbitration mane
Land Counsel for the petitioner took some time to examine this, put up this matter. Next week, no?
चौदहटा विषय
both are same.
30. Next.
Item 15.
Matter pertains to land acquisition, and the land was acquired in the year 1987, my lords, by virtue of order passed by the Honorable High Court in 36066/2013. The Honorable the Honorable High Court has directed to the Section 4 to adjudicate the matter and give employment to the petitioner, whereas they have rejected the
you earlier approached this court.
My lord.
In WCC number
36066/2023.
So where is that order?
I am not filed, but the order which has challenged for my lord, Annual A1 P1, Annual 1 page 13.
I just want to see that what was the exact order.
Only representation was decided, my lord.
The order in the writ petition.
I have annexed Annual P. Annual 6 page 24. My lord,
this order was passed of the observation or whatever it may be.
My lord.
So neither you have filed that order nor you have extracted the order in the writ petition.
My lord, it has not been extracted, my lord. No. My lord. And what my submission before my lord, the annexure A6 page, this is page 24, which has been disposed by the respondent 4 to adjudicate the representation in so far as writ petition is concerned, my lord. Annual 1 page 13, it is clearly stated, my lord. Whereas Manas and Pradhan, herein after petitioner filed writ petition number so and so 2013 before the Honorable High Court of Odisha, Cuttack to conduct inquiry and assessment of the application, condition the petition providing compensation as well as employment in Mahanet Coalfields Limited, implementing state of Odisha, represent through the Department of Revenue and Disaster Management, Department of Odisha, Secretariat, Annual P1, opposite party number 1, Collector Jharsuguda, opposite to now 2, Land Acquisition Officer, this is opposite 3, and GM, MCL, opposite party number 4. So here the GM has disposed the representation which has been ordered by the Honorable High Court and reject representation on the ground that though the 11-1 notification has been issued to you and you are not submitted your documents proper on 24/11/22, but he has submitted that I have already submitted all the papers and the manager from manager 3 to copy of display certificate which is issued by the page 19, my lord. Kindly peruse page 19. The petitioners have displaced from the date of the Hiraku Dam projects. This certificate for Tahsildar. The reference to subject cited by and to say that display certificate cannot be issued by.
Let us see that 1957 Act.
My lord. So, my lord, here, my lord, the respondent has issued manager 2, page 16, my lord. Under section 12 and 17 of poll bearing.
Mr. Counsel,
My lord.
just have patience towards the provision.
Poll bearing. My lord, poll bearing act I am not having now, but
Why have you come? You are arguing a matter,
My
and you have not brought the book. Everything is in your case. We'll
no,
sit then.
I have not said.
Put up this matter next week. Yes.
My lord. I will file the.
Yes, next.
My lord.
Item 16.
My pillars. Chairman, my recollection pending before the opposite party matter under Annex 3 and 5 matter for payment of enhancement of compensation. My land was acquired by the opposite party matter. Annex 3 and 5 matter.
What you want here?
I pray my representation will be considered.
What representation?
For enhancement of compensation.
Who has awarded the compensation amount?
Opposite party land is officer. Opposite party 1 matter.
So your application, where is the application?
Representation is
My
Annex 5.
5 and 3 also.
But there is no proof of any receipt of acknowledgement.
3 times.
No. If suppose you are dissatisfied with the award,
Yes.
so is it the only option available that you will file a representation and he will enhance the market value, or some other provision is there in the act? So the authority has fixed a particular amount. Awarded
Yes.
amount has been fixed.
Land acquisition case order is.
And if you are aggrieved by it, whether that can be sorted out by filing a representation, or there is other remedy available to you.
I pray for sorted.
Huh?
I pray for sorted. I pray for
Examine it. So everything cannot be this. Representation will not do. So see the provisions in the
Yes.
act. Somebody is not satisfied with the award, what he has to do. If there is a authority prescribed, and you have to approve that. It seems that the petitioner is not satisfied with the awarded amount which was passed for acquisition of his land in Moza, Godopalli, under Khata number 30/3 and Khata number 27. And he has filed the representation to the collector cum district magistrate Sundargarh, opposite party, for enhancement of that amount. During course of argument, the land counsel for the petitioner seeks for an adjournment to verify whether this specific provision in the act to approve for enhancement of the awarded amount or not. Put up this matter. Ever of your phone.
Okay.
Then
Authority oblique forum.
and was it awarded in LA case number 24 of 2007?
Yes, ma'am. That is the case number.
In connection with LA case number 24 of 2007.
24.
2017. So you Mauja Swansu said in land acquisition case number 24 of 2017. Yes. Yes.
Item 17.
I please. The petition is the education trust. Let's turn to page 23. The OSFC transferred in terms of section 29 in favor of the petitioner by on outright basis 1 crore 50 lakhs 50,000. That is at page 23. Way back on 25/6/2012. Let's look to that page 23. That OSFC letter. That is at the cost of 1 crore 50 lakhs 50,000 on section 29. And the last line also see that the trusts are also hereby authorized to take necessary action for change of ownership to their name and necessary correction to that effect in all government records as the owner, real owner. Then also kindly come to page 24. The OSFC on 25th June 2012 entered into agreement for sale with the petitioner trust, and at page 29, clause 3, the vendor will issue letter to the IDCO. That means OSFC will issue letter to the IDCO for transfer of ownership of the following properties in favor of the vendee. The vendee will bear all expenses, that is stamp duty, registration, etc., of the registration of lease deed in the sub-register office by IDCO. Then number of correspondence were made on the Annexure 3 series. No lease deed was executed, but at page 34, on 7/4/2018, IDCO addressed a letter to the petitioner trust that you are required to deposit 73,44,156 as towards the deposit of transfer fees, and that was also deposited at page 45. That at Annexure 6 that was deposited. After deposit, on 13/1/2020, Annexure 7 at page 46, 2 years after, this letter was addressed to the petitioner by the office of the IDCO. If you also look to page 47, that is important. Page 47, clause 10, Raut Education Trust petitioner shall have to start the activity of their project within a period of 6 months from the date of issue of this letter, following which the IDCO will be free to take appropriate action against you as deemed fit. And the next page, you also see page 48, para 16. In case Raut Education Trust will take off any new construction to the existing construction, or you have already constructed, shall have to obtain approval of the construction plan for the competent authority. Such construction should be made strictly as per the approved plan. Approval is required to be done by the IDCO. Then at page 49, they said that in the above terms and conditions of this order are acceptable to you, please communicate in writing your acceptance thereof to Decana head concern and complete the requirement stipulation within 1 month. That was done by you. Then if you also look to page, after 2.5 years at page 51, the lease deed was executed. They said that within a period of 6 months you start, but after 2 years, that at page 51, that is on 8/12/2022, the lease deed was executed, registered lease deed, that was by the IDCO, that starts from page 51. And if you also look to page 54 of that lease deed, that is very important. That itself, how it is income, page 54. Para 3. Let's look to that. Clause 3A. In case the lessee wants to take new construction to the existing construction, if any, only after obtaining the approval of the construction plan from the competent authority. Such construction should be made strictly as per the approved plan. The construction plan shall be prepared as per the norms fixed by the approving authority. Then B, the lease shall have to start commercial activities on the allotted property within the 6 months from the date of issue of the transport order dated 13/1/2020. Otherwise, the property shall be reverted back to IDCO free from all encumbrances. 13/1/2020, they have not registered, Annexure 7. They again look to that. That was only a letter on 13/1/2020 where they said so. Now they say in 2022 that 6 months from the date of issue of the transfer order dated 13/1/2020. But by that time, it was not registered or executed. Then at page 64, you can also look to page 64. Then I submitted a plan also. At page 64, Annexure 9, they issued a show cause. 12/4/2024. 12/4/2024. You also see the 1 and 2. The land allotted is not being utilized for industrial activities for the purpose for which it was allotted. And two, you have defaulted in payment of 94,000 some odd only towards heir and IMC, that is ground rent. That also I deposited, that 94,000 that has been deposited at page 66. And I informed them immediately, page 66, that I gave the reply in the show cause. But so far the first part is concerned, the land allotted is not being utilized for industrial activities for the purpose for which it was allotted. I have submitted the plan. That plan also, you also look to page 67. That again on 25/4/2024 I submitted the plan, but without approving it, while you submitted the plan, they said that you deposit the scrutiny fee. They also look to page 69, Annex 11. That is on 5/9/2024, they asked me to deposit the scrutiny fee, that is 29,015 rupees, to be deposited for the purpose of approval of the plan. And that I deposited to the next. You also look to that on the RTGS, Annex 12, serial number 1. That was deposited, serial number 1, on 10/9/2024. Despite that, again a second show cause was issued on 7/1/2025. Same thing, reproducing the same. Land allotted is not being utilized for industrial activities, serial number 1. And that also I get the reply at page 74. That I have already submitted the proposal for approval, that is pending. I have deposited scrutiny fee, that is not being done. So again at page 76, third show cause has been issued. They are likely to cancel my lease on that ground alone. That is the entire case of mine. Third show cause, that is page 76. Even without referring to the earlier one, my proposal for approval of the plan, I have deposited the scrutiny fee as they required. They accepted it. And that too, lease deed was executed in 2022, registered was made, and they refer to 2020, and that is only a letter. And they say that you should have done it within a period of 6 months from the date of the transfer. That is from 2020. And I have got the no objection certificate from the state government for so far as the establishment of the unit is concerned. That
this annexure 15, as it appears,
yes, sir.
It is the final show cause notice.
Yes, they say that this is the final show cause, but same thing. The earlier two show cause is same. Repetition of same.
Same, and it has been signed on 3/1 and dated 3/2. What is this? I can't understand.
Total non-application of mine.
Date of signature. They are not referring to your show cause reply.
Nothing of that. Nothing of that. And scrutiny, they also asked me to deposit the scrutiny fee. I deposited.
Scrutiny of your show cause reply?
No.
Documents.
Proposal did approval पे. Building plan.
67 or 69 is a reply. 67.
This is who is appearing for this info.
I have to take notice. I have to take notice.
The petition has been filed by petitioner Routh Messrs. Routh Educational Trust. With a prayer to set aside the Super's notice dated 12/4/2024 under Annexure 9 and 7/1/2025 under Annexure 13 and 3/2/2025 under Annexure 15. Mr. Rautel and Senior Advocate, referring to various annexure subject that time to time the authorities have asked the petitioner to deposit the money for different purposes, and the same has been carried out immediately by the petitioner. And in spite of that, without any fault of the petitioner, repeated show causes have been issued to the petitioner. And even though the petitioner has submitted his reply to such show cause notice, the same has not been taken into account. And the last one, which is dated 3/2/2025, also doesn't indicate that at any point of time which was submitted by the petitioner has been in pursuance to the earlier super's notice has been taken into account. The land council submits that the petitioner apprehends that in pursuance to the final super's notice dated 3/2/2025, there would be cancellation of the lease deed executed in favor of the petitioner under annexure quote as a lease deed.
It is annexure.
They put the place
Annexure 8.
Annexure 8. Executed on 8th of December 2022. Issue notice on the question of admission indicating therein that the matters shall be disposed of at the stage of admission. All these parties are to be noticed.
Yes, I give you
requisites for issuance of notice by speed post with proof of delivery shall be filed within a week. Matter will be listed 4 weeks after. IN numbers one, so till next date, no possible actions shall be taken against the petitioner trust. Yes. Persons to annexure 15. Yeah.
Item 18.
May it please the Lordship that the present petitioner was allotted land in the district of Bikaner for the purpose of setting up a hazardous waste treatment plant. But by Annexure 1, on dated 3/2/25, a letter has been issued for cancellation of the said land on the ground that in terms of the allotment letter, I was supposed to complete the project, start the construction work and complete it within 3 years from the date of allotment. This letter has been issued on signed on 31/1/2025, but issued on 3/2/2025. And without taking your lordship to the allotment letter, may I take your lordship straight away to the lease deed? It comes up this Annexure 5, page 41.
No, you are challenging Annexure 1.
Yes.
Come to that Annexure 1.
Sorry. Annexure 1, page 16. May I read it?
Please read it.
I'm sorry. In inviting reference to the letters on the subject cited above, I am directed to intimate that ITCO has allotted lease out land, government land measuring 12.5 acres in village Patrapada and the Purgent Parcel in the district of Bikaner to set up an integrated storage and disposal facilities at Patrapada and the Purgent Parcel in Bikaner district by Mrs. Western Integrated Waste Management Facilities Private Limited, the petitioner herein, in 2022. In the meantime, 2 years, 4 months have passed, but you have not started construction activities other than constructing the boundary wall. As per the allotment letter, clause 18, if construction work is not started within 6 months, the lease will be deemed to have been cancelled at the end of 6-month period. Further, if the land or any part of it is not utilized fully for the purpose for which it was sanctioned within a period of 3 years, the same shall revert to ITCO free from all encumbrances.
Yes.
Next, in your communication, in your earlier communication dated 18/6/2024, you have mentioned that you are committed to start civil construction activities by the end of August after monsoon. Hence, you are requested to show us within 15 days from the date of issue of this letter as to why the allotment of land measuring 12.5 acres in village Patrapada made in the office letter number so and so dated 26/9/2022 will not be cancelled.
Yes, then what you have done?
Against this, I have come directly.
No, why you have
the reason being, I'll just explain the reason. That may I take your lordship directly to the lease deed matters. There are 2 documents I'll take your lordship. Annexure 5, page 41. Again. My lordship, kindly take lordship at Annexure 5, page 41.
Yes.
My lordship will kindly straight away come to page 51.
Yes.
Clause number 7.
Hmm.
Force measure. Neither party shall be liable to the other party for failure to perform its obligations hereunder due to the occurrence of any event beyond the control of such party and affecting its performance, including without limitation to government regulations, orders, administrative requests, rulings and orders. I lay emphasis on the word rulings and orders. Acts of God, warlike hostilities, civil commotion, riots, epidemics, and any other similar causes. But in this present facts of case, and case was filed before the NGT. It was a party to the case. NGT has now held that this is a forest land, basing on the fact that the remarks column said it was a Sabik Kisam land. May I take your lordship to Annexure 11? Page 64. The relevant portion, my lords. Page 82, paragraph 45. It was a party, it appeared in these cases, my lords. Thus, on a conspectus of facts of the case and documents on record, we hold the land to be subject to some jungle, and we direct that the respondents shall not carry out any construction or other activity in the said land until application for the said use of land for non-forest purposes is filed before the central government as required on the provisions of Section 2 of the Forest Conservation Act, and such permission is granted by the central government under Section 2 of the Forest Conservation Act.
Is it the same land?
It's same land, my lords. It is the same land.
How can we?
I'm a party to this, my lords. May I take your lordship to state?
How can we know?
Page 66, my lords. It is the same land, my lords.
Just a minute.
Page 65. The allegation.
Land describe food portion. Page 66.
Again. Page 65. I am the opposite respondent number 5-7 here. And it is same case. And may I take the lordship?
You are in this case opposite party number
7, I guess.
7.
Respondent number 7.
Paragraph 3 of the order.
Again, it's submission record and it is in respect of the same land, same khata number. Same plot number also.
So, this order which was passed by the NGT,
my lord,
in that original application,
my lord,
it is to be challenged.
Yes, my lord. We are now contemplating challenging it also, my lord, because the reason being, here it goes, the state, everyone says that it was a non-forest land, yet they say that though the Kisam it is saying toiler, however we rely on the remarks column. But
why
remarks
don't
column
you bring all these matters that you are doing, asking me to complete it within so and so, but NGT order
Annexure
is there.
6 minutes. They are party to it and Annexure 6 minutes. May I take the lordship straight ahead to Annexure 6 minutes. Page 56, dated 12/5/23. I intimated them that this matter is pending in NGT. Please take.
No, that is earlier. So far as this so-cause notice is concerned, so the so-cause that you are requested to so-cause within 15 days.
Yes, ma'am.
So you can bring all this matter, factual aspect, that NGT order is there and in which you are also a party.
My lord.
This ITCO is also a party,
yes,
perhaps that.
Okay, number 6 over there.
This order is, and we are contemplating to file SLP or whatever it may be in the challenging that order. So, for in view of this reason, you should not proceed with this. So why
I'll file. Till that time, at least.
Because in the previous case you saw, they have approached. Thereafter, they did not consider. That is right.
Till that time, at least something.
The writ petition has been filed by the Western Integrated Waste Management Facility Private Limited, challenging the so-cause notice dated 3/2/2025 issued by the opposite party number 3.
Who is Mr. Deepak Wani? Look at the cause title. It's a company you have to specify.
He's the CEO.
So what have you stated in your cause title?
CEO କି managing director କଣ ଲେଖା
True. I'm sorry, we should have written minutes. My apologies to that. Chief Executive Officer.
Who is that Dipopani?
He's the chief executive officer working with the company minutes. We should have written CVM, my mistake.
And Wakalatnama has been signed
Yes, madam.
by that man.
Yes.
At what capacity?
Paragraph 3 you have stated.
Yes, ma'am.
Authorized signatory.
Yes.
Chief executive.
Again.
अच्छा, petitioner represented through Karjantu, so and so. He's the what is his
Chief executive officer.
Chief executive officer. Wherein the chief general issued by the chief general manager, that is opposite party number 3. That to file the so-called by the allotment of the land measuring 12 acres 5 decimal in village Patrapada, made in the office letter number 22777 dated 26/9/2022 shall not be cancelled. That is page number 17 at that page. The land counsel for the petitioner, referring to the what is that NGT order?
Annex 11, page 64, minutes.
Referring to the order dated
31/1/25. Again, 65 page CORAM upare date of hearing.
31/1/2025 submitted that it has been held in paragraph number 45 of the order that the land in question is a Sabi Kishan jungle, and the respondents were directed not to carry out any construction or other activities in the said land until application for use of the said land for non-forest purpose is filed with the central government as required by the provisions of Section 2 of the Forest Conservation Act 1980, and such permission is granted by the central government under Section 2 of the Forest Conservation Act 1980. The Land Council for the petitioner submitted that the petitioner was respondent
number
7 in the said proceeding. Original application number ta likhi debe se jo NGT order passed in original application 39/2023/EZ, and therefore the petitioner is contemplating to challenge the aforesaid order passed by the NGT before the appropriate forum, and that was the main reason why the construction work has not been carried out in the land in question, which appertains to land details ta kod lekha hai ji pehle
खाता number allotment letter
lekha hai na खाता
allotment letter annex 4 page 34 again.
kodi lekha hai ji
page 53 these details schedule hai
page 53
again page 53 these details schedule hai
just in land which appertains to that is Mauja Uchi Patrapada na
Again,
Mauja Patrapada खाता नंबर होची 985/532 plot number होची 3 and area होची एकर होची 6.500 आउट होची सेम मौजा स्वांसु खाता नंबर एटा मेंशन ହେଇଛି ଏଥିରେ पेज नंबर 53 रे दीटा land particulars mention ହେଇଛି दीटा ଲେଖିଥିବ. The land council after arguing the matter for some time submits that he wants to file a reply to the so cause notice under annexure 1 giving all the details and within a period of
15-20 days.
he has given period as expired today.
Again.
2 weeks. 2 weeks time. Within 2 weeks, the writ petition is disposed of, giving liberty to the petitioner to file reply necessary. The personal hearing shall be afforded to the petitioner to his case, and the order passed on the after considering the reply shall be communicated to the petitioner within 15 days of taking the decision. Till no coercive action shall be taken till so and so. Till you file it by 28th.
Is the application filed by
3 तारीख 4 तारीख
Achha, all right.
4 तारीख
If the reply is filed by 4th of March 2020, the submit that so and so till 4th of March 2025.
4th of March is the file करियो. So the file है
till
till
the
decision
till the
communication.
till the decision communication is made, no coercive actions shall be taken against the petitioner.
urgent setback.
Urgent setback.
Deep level.
Please, Your Lord. Item 19. May please, Your Lord. Lordship, petitioners are the association of affected farmers on whose land the watershed department has built a embankment, and subsequently the embankment was widened, a road was made upon it, and now the guardrails are being taken while widening the embankment without paying any compensation. The petitioners approached the authorities several times, but
your land has been utilized, but it has not been acquired.
Not been acquired. No notification.
To what purpose it has been utilized? For that canal embankment?
Embankment. I've annexed photograph at annexure 1, page 20.
River embankment. So, is there any document to show that, or is there any communication from their side to show that yes, your land has been utilized for this embankment, construction of the river embankment?
Lordship, there is a tender call notice at annexure 2, page 27.
Just a minute. Annexure 2, yes.
Page 27. The relevant portion is at page 28, serial
Yes.
number 4.
Serial number 4.
May I read it?
Yes.
Protection to Mahanadi right embankment from Rana to Kathasankha. And serial number 11 at page 29. That is improvement to road on the Mahanadi right embankment from Rana to Jatamundia. First one is the protection of the embankment, that is widening of the embankment, and second is the road, motorable road on that embankment. And other thing is that widening, that guard wall, Your Lordship, that is not being, the tender is not in the public domain.
No, we are not on that. We are on a point that your land has been, without initiating the land acquisition proceeding, your land has been used for construction of that river embankment. So your prayer in this writ petition is that they are to initiate a land acquisition proceeding and pay compensation to you. Or if your land has been utilized, then the other recourse are available to him that he can make direct purchase from you, even without initiating that proceeding. So, have you given the details of the land which has been utilized for such purpose?
Lordship, the petitioner is an association of persons. All the details of those
Mr.
members.
Counsel, you are to indicate that which are the plots, what is the area, what is the khata number of those farmers which are stated to have been
Lordship,
utilized.
kindly refer page 41 onwards. It's there.
What is there, 41?
Serially, the land and the area is.
You see, XYZ land has been utilized. They are not coming to the court. Under what capacity you are approaching this court? Who has authorized you? You are an association.
Association.
Which association? Farmer Association Banki.
Lordship, the resolution is at page 40. Paragraph 2 and 3.
Just a minute.
Registered association?
Unregistered.
Unregistered.
See, unless you give all those details, you are right that suppose the lands of these farmers have been utilized for a particular purpose, like they are entitled to get compensation. And but those details are to be, if we ask the London State Council to obtain instruction that to see whether the land of has been acquired or land has been utilized for the, so then they have to be furnished with all those details so that they will verify it and at least say something.
Lordship, I'll furnish it.
You are not giving anything.
Sir, the association through their council held a representation before the chief secretary. That is an annexure 5. And that application is also processed, annexure 6. Acknowledgement receipt is at annexure 6.
So good, if it is processed, they will deal with it.
Yes.
No necessity
No,
for
your
the
Lordship, it is
petition.
not processed. Your Lordship, is not processed.
Then the process means they have acknowledged it that they have received this.
ଶୁଣନ୍ତୁ ଶହ ଶହ ଆପ୍ଲିକେସନ ଇଏ ସବୁ ଆପଣଙ୍କର ନେଇକି ଗଦା ହଉଛି ସେଠି, ତେଣୁ କ୍ୱେଶ୍ଚିନ୍ ହଉଛି ଯଦି ଗରିବ ସେମାନଙ୍କର ଜମି ଗୁଡାକ ଇନଫ୍ୟାକ୍ଟ ଆପଣ ୟୁଟିଲାଇଜ କରିଛନ୍ତି ରିଭର ଏମ୍ବାଙ୍କମେଣ୍ଟ ତିଆରି କରିବା ପାଇଁ, ତାଙ୍କୁ କମ୍ପେନସେସନ ଦେଇନାହାନ୍ତି, so they are to get the compensation. ଆପଣ ଆକ୍ୱାର କରନ୍ତୁ, ଆପଣ ଡାଇରେକ୍ଟ ପରଚେଜ ନିଅନ୍ତୁ, ଯାହା ବି the question goes to the root of the matter that ହେଇଛି କି ନାହିଁ ତାଙ୍କର, ଏବଂ ଯଦି ହେଇଛି ଏଇ କୋଉ ଜମି, ତ ସେଇ ଯୋଉ ଡିଟେଲ୍ସ ଗୁଡାକ ସେମାନେ let them furnish and
I'll obtain instruction.
no, unless they furnish it to the details, how can you obtain instruction? ଆପଣ କହିଦେବେ କି ଆପଣଙ୍କ ରିଭର ଏମ୍ବାଙ୍କମେଣ୍ଟରେ କୋଉ ଜମି ଯାଇଛି, ଏଇ ଯୋଉ ଜମି ଗୁଡାକ ଏମାନେ କହୁଛନ୍ତି ତାଙ୍କର ଯାଇଛି ସେଗୁଡାକ ତାର ଡିଟେଲ୍ସ ଦେଲେ ଆପଣ you can ascertain something. Otherwise it is very difficult because nothing has been mentioned in the this writ petition. Have you mentioned anywhere? Then
Lordship, I have IA for measurement under section 12 of the land. If the collector measures the land, then each of the land will be, they will get the details of each of the land.
that we can direct, you can approach the appropriate authority. Measurement, so you file a detailed list in indicating that what are those lands which according to you has been utilized for such purpose. This writ petition has been filed. for a direction to the opposite parties to initiate land acquisition proceeding under section 11 and section 15 under section 15 of the right to so and so 2013 and to compensate the affected farmer members of the petitioners in accordance with the provisions of 13 Act. It is the contention of the Land Council for the petitioner that the petitioner number 1 is the Farmer Association of Banki, and who are petitioner number 2 and 3?
Those are petition number 2 and 3 are the landowners whose land is also taken, and they are the members.
And the petitioner number 2 and 3 are the landowners whose lands have been utilized for construction of the river embankment. It is further submitted that till date no land acquisition proceeding has been initiated, nor any of the farmers whose lands have been utilized have got the compensation. However, the land particulars have not been mentioned anywhere in the writ petition.
Lordship, I beg pardon. I've annexed the land particulars to the membership details.
Yes.
I've annexed that from page 41 onwards. It is serially annexed with the membership number and the details.
This is not legible, Mr. Paul.
Yeah, but you have given the details membership, but which plots have been acquired?
दियंतु आपण गोटे लिस्ट करिकिनी एई लोक तार एई प्लॉट तार खाता नंबर या अमुक या सेटा रिभर गोटे डिटेल्स दियंतु हलो he wants to submit a detailed list with an affidavit about indicating the names of the farmers and the details of the land which stated to have been utilized for construction of so and so, giving a copy to the Land Council for the state. Put of this matter. How much time you require?
Any day, Your Lordship. Any day.
No, any day, man.
7 days.
With 1 week time we request, and so matter will be listed in the week commencing from 3rd March 2025. Collect all the details, okay, and mention it serially. Yes.
Obliged.
Item 20.
As per noting this, as per steps for limitation not taken.
Mr. Counsel, you are Mr. Bevra.
Okay. Deficit court fee, written perception not yet. In court, I have already paid the deficit court fee today, and 2 weeks time can be granted for filing of IA for limitation.
Land Council. What is your good name, Land Council?
Dr. Behra.
P.K. Behra. Mr. P.K. Behra, Land Council submits that deficit court fee of 25 has already been paid today. So far as steps for limitation is concerned, you take steps within 2 weeks. 2 weeks. Matter will be listed in the week commencing from 17th of March 2025. Yes.
Item 21.
But in this review petition, the petitioner seeks review of the Lordship's judgment dated 2/11/2022 under Annex 5 at page 19. The facts of the case is like that, my lord.
Oh, there is a delay or what?
Yes, my lord. There is a delay of 700 some odd days, my lord.
So, what? 734?
Yes, my lord.
So, notice has been issued?
No.
It is coming for the first time?
First time.
What is it? Why should we fill this out?
'You are challenging which order?
2/11/2022.
Yes, sir.
So you were represented by a counsel.
My lord, I am appearing for the second wife, my lord. And
Second wife.
yes, ma'am. She was not made a party. And furthermore,
Second wife, why should be she made a party?
My lord,
Second wife.
no, my lord. Yeah, my lord,
The first wife is living.
yes, first wife was there. There was divorce proceeding filed by the husband
Hmm.
against the first wife on the ground of desertion.
Hmm.
The husband succeeded him.
Hmm.
And thereafter, an appeal was preferred by the wife. And during pendency of the appeal, the husband died.
Died.
Yes, my lord.
Okay.
And thereafter, an application was filed seeking substitution of the husband by the daughter. And admittedly, my lord, the daughter was residing with the wife all through. And the question fell before the Honorable Apex Court, similar circumstances.
No, what has happened in this case?
So now,
what happened?
Now, my lord, the daughter was substituted in the place of the husband. And thereafter, the decree of the family court, my lord, it was set aside. Honorable Apex Court has held that the right to survive, the right to sue survives on two grounds. One is its personal cause, even if it's a personal cause, since it affects the property rights, so therefore the right to sue survives. But it is mandatory for the party who wants to continue with the proceeding to bring all the legal heirs of the deceased. But over here, my lord, only she brought in on record the daughter, and admittedly the daughter was residing with her. There was a limitation of more than 2 years. No application for delay condemnation was filed. And so these are the facts, my lord. So therefore, it's a case of
Second wife, how is she the legal heir?
my lord, second wife, since I was married pursuant to the decree, my lord, of divorce. So therefore, my lord, I have filed this review petition. And I filed this review petition on the ground that fraud has been practiced upon this court by not bringing all the legal heirs of the deceased on record, my lord. The husband's father was alive. He was not made a party.
So you are seeking a review of the order dated 24/9.
Yes, ma'am.
Okay, where your IA has been dismissed.
No, I am seeking this is on 2/11/2022, the judgment, my lord. After the judgment, under Annexure 5 at page 19.
What is that judgment?
Okay. Yeah, IA was dismissed, but liberty was granted
Yes,
you
ma'am.
to.
Yes, ma'am.
Okay, so thereafter you filed this review.
Yes, ma'am.
Okay. I would have filed for IA for setting aside the order. So IA was obviously dismissed, treating that up.
Regional Assembly, Subhasini Maharana and Valentine Sahani. They are the opposite parties.
So when did you marry? You've given your marriage certificate? Or
Yes, ma'am.
where is it?
Not you would see a
Next
page,
year?
running page 31, my lord.
Running
of the
page
brief
31.
On 22nd February 2020. And thereafter, my name has been entered in the Aadhaar card. My husband's name has been reflected in the Aadhaar card.
What's that? Where is your marriage?
On 22nd February 2021.
Marriage invitation card.
That is
Invitation card. And thereafter, you would see the Aadhaar card, where in my Aadhaar card, my husband's name has been reflected. And again, in the passport, the next page, again, my husband's name. And even, in fact, in the service records, my lord, my name stands reflected. It's only when I was called by the employer for the death benefits and all, there I learned that such a thing has happened. That the judgment of the trial court has been set aside.
Your husband filed a divorce case.
Yes, my lord.
Against the first wife. Let us say, and that suit was decreed in his favor. That means against the respondent.
Yes, my lord.
Right? And against, of course, he was directed to pay permanent alimony So that was the subject matter of matrimonial appeal filed by the
husband.
Filed by the
So far as the alimony part is concerned,
alimony part husband challenge
again,
and divorce part the wife challenge.
Yes, sir.
So two MATA were filed.
Yes, sir.
And those were disposed of by common order.
But so far as the appeal preferred by the husband, that has probably that has been disposed of. But this judgment is only in the appeal preferred by the wife.
No, just a minute. MATA number
13 filed by the wife, madam.
This is against the divorce, of course. So, what order was passed in this MATA 13 of 2020?
That probably it was since I'm not aware of it, but must have been.
It goes to the root of the matter because in that matrimonial appeal case,
yes, sir,
this interim application has been filed and then the order has been passed. Now you are seeking review of that. So when this, whether it has been, you are not aware even that whether this matrimonial appeal has been disposed of or not.
But
it appears from that order dated 24/9/2024 that MATA number 13 of 2020 has been disposed of. Come to the order dated 24/9/24. In passed in IN number 31 of 24, which you have annexed as Annexure 7.
Yes, sir.
Annexure 7 को आसंतु Annexure 7 टा होची order dated 24/9/2024 in IN number 31 of 24, where in the second paragraph it has been mentioned that MA number 13 of 2020 has been disposed of.
Yes, sir.
We want to know that what order was passed while disposing of the MATA, whether that order was set aside or confirmed, because the wife has filed that MATA.
Yes, sir.
Challenging the divorce decree.
Yes, sir.
Passed in favor of her husband.
Yes, sir.
You were nowhere in the picture, at least in that proceeding before the family court. You were not there. So obviously you could not have been made a party in the matrimonial.
Initially, I was made a party.
In which case?
In MATA number 13.
No, we do not know that. Where is that order?
Your Lordship would, I'll just take my measure. Your Lordship would see Annexure. Annexure 1, page 10.
Yeah.
But on 7/3/2022, in the present appeal where the judgment is being sought to be reviewed, the matter is taken up. Heard, the sole respondent is stated to have been died on 11/11/2020. Keeping the question of admission open, the appellant may take steps of substitution in the meantime. And thereafter, my lord, this interim application is filed by the wife seeking substitution through her daughter. And thereafter, your lordship would see under Annexure 3 at page 15, the substitution sought for the wife's sole respondent as per the schedule is allowed. The daughter of the sole respondent is be substituted as respondent number 1A. So in place of the husband, only the daughter has been substituted. Consolidated cause title will be filed.
So how do you say that the application was filed for substituting you?
Application was filed for substituting the daughter because
so if let us say that the husband of the applicant or appellant in matrimonial appeal died and he was required to substitute the legal heirs of the respondent husband.
Yes, ma'am.
And that is how he filed. So why, whether it was necessary to implicate you in that interim application for substitution?
But since by that time I was already the legally wedded wife of the husband, so therefore I was also one of the legal heirs. So I should have been made a party. And also at the same time, the father was also alive. The father of the husband was also alive. And the wife was very much aware of that fact. Even the father was not deliberately made a party.
No.
But the daughter, my lord.
After all, what order, final order has been passed? Because matrimonial appeal is stated to have been disposed of.
Yes, my lord.
We just want to know that what is the final order was passed.
The final order, the
Where is
decree of
that
the
order? Please show us.
yes, my lord. You would see at annexure 5 at page 19.
And when did your husband die?
On 11/11/2020, my lord.
11/11/20.
Yes, my lord.
So within 9 months of marriage. 11/11/2020.
During pendency of the appeal, my lord.
Why are you relying on the Aadhaar card?
My lord, those are the documents to.
No, just look at the Aadhaar card.
Yes. Gagi Biswas.
Yes.
At the bottom, care of Pramod Kumar Sahani, my lord.
So care of, you could be the house owner also.
No, my lord, Aadhaar card.
Aadhaar card mentions the name of the husband as care of.
My lord, you would see the next passport.
No, I am asking about the Aadhaar cards. That's why I asked why you relying on the Aadhaar card.
Aadhaar card, my lord, Pramod Kumar Sahani is the admittedly the husband.
Who admits? It is care of.
Care of, like,
Yes.
And if by order dated 2/11/2022, which we are showing at annexure 5, page 19, the divorce decree has been set aside.
Yes, my lord.
So obviously, the lady becomes the wife, the first wife of the respondent, deceased respondent. So their marriage obviously took place much prior to your so-called marriage in the year 2022.
Yes, sir.
Right. So if that is so, then what relief you can get? All these things arises because to get that
property rights.
Property.
Yes, sir.
Right.
The law which has been propounded by the Honorable Supreme Court is that in a divorce proceeding, what would be the case if either of the spouse dies? But if the proceeding is pending before the trial court, before the family court, then the proceeding would abate with the death of either of the spouse.
Yes.
Then what would be the case in case if a divorce has been granted? My lord, the Honorable Apex Court has held that the right to sue survives because the property rights are involved. There is a stigma involved. But at the same time, it is incumbent on the party to implement all the legal rights of the spouse. But over here, what she has done, admittedly, my lord, the daughter was residing, the case was filed on the ground of desertion. Daughter was residing with the wife all through, my lord. She files an application seeking substitution of the husband by the daughter, only the daughter, without impleading the father of the husband, who was alive at that point of time.
Father of the
husband.
Father is not before us.
He is not before us.
And also me, my lord. Because by that time I was, my lord, after the decree of divorce, I had got married, my lord.
So you had invited them to the marriage?
My lord.
How will they know that you are married?
My lord.
When you see
when she's pursuing a litigation against the husband, my lord,
no,
she would be aware of
when the order was passed. Let us see.
Yes,
the in the family court. What is the date of the order?
2011-2019.
2011-2019. 22/11/2019. So there is a that if divorce is an order is passed, then you cannot remarry. There is a period is there.
Yes,
because there is likelihood of filing the appeal against that divorce, which has been done in this case.
Yes, my lord.
And he may
but at the same time, my lord, whether the marriage is a nullity or void, my lord, a declaration had to be sought for. Nothing, my lord, my marriage stands as it is. Because in view of section
Let
11,
us see if the marriage is within that period or
it's within that period, my lord. I would consider it was within that period. As section 15, it says that the spouses are free to marry only after the period of appeal.
Right.
But over here, my lord, section 11, my lord, short that the marriage is void. There is no declaration. So admittedly, there are two marriages subsisting.
The question is, he could not have married you unless that statutory period of appeal is over. That is in the family Hindu Marriage Act and Family Court Act.
Section 15.
So once an appeal is filed, that operates as a stay.
You cannot marry.
No.
Unless it is dismissed.
Yes, sir, that's correct. But
which is that provision?
Section 15, my lord.
15. Please read it out. So either so and so right of appeal, so and so. And if there is a right of appeal, the time for appealing has expired without an appeal. So
filed within time.
His time. So how can you marry that? He can marry.
No, you can marry.
Yes, sir.
Why?
But
What rights will you acquire?
Right. In view of Section 15, my lord, it's a nullity. But at the same time, it has to be declared because Section 11 also says, Section 5 read with Section 11 of the Hindu Marriage Act says, my lord, that if a marriage is void, it has to be declared, my lord. But now, my lord,
Section 15 is clear. Why does it have to be declared?
But void.
That is different. Void marriage is when you are underage or you are within those restricted relationships.
5-1, my lord. 5-man. A marriage may be solemnized between any two Hindus if the following conditions are fulfilled. Namely, neither of the party has a spouse living at the time of marriage.
Yes.
So, my lord, now in view of Section 11, any marriage solemnized after the commencement of this act shall be null and void and may on the petition presented by either party thereto against the other so be decree of nullity if it contravenes any one of the conditions specified in clause 1, 4 and 5 of Section 5.
Here. That is not applicable here.
But one, my lord, since there was already a marriage, because by that time the decree of divorce had been granted. And after the decree of divorce was granted, I got married.
Section 15 is clear.
In view of Section 15, if that period would have expired, that appeal period, and thereafter
and no appeal was presented,
and then you got married, thereafter, let us say, she files an appeal, then matter would have been different. Here, within that, have you verified that it was filed within the stipulated period or not?
But in violation of Section 15, if the marriage took place.
What is the period it says that the order of the family court can be challenged?
90 days, my lord. As per
just come to that provision.
Admitting that titles.
The appeal provision is there?
Yes, my lord.
Family Court Act.
There's a division. I think larger bench
Family
decision
Court
of this
Act
court.
wrong.
That will be 60 days.
Which is an appeal. Family Court Act, Section 19 perhaps is that provision.
Well, Section 19 says 30 days, but Hindu Marriage Act, my lord, Section 28 says it's 90 days, and that amendment has been made after the Family Court Act. So 90 days would prevail. That is a settled point.
There's a decision of this court that 30 days, but anyway.
No, but
okay, if you insist, it's all right. That will finish.
No,
if you insist, it's okay. All right.
Now, this Section 19 says that it is to be made within a period of 30 days.
30 days.
Submission in the Hindu Marriage Act.
Yes, sir.
What is that provision?
Section 28.
28.
Yes, my lord. 28(4).
Just a minute. So there it is 90 days.
Yes, my lord.
That matter has been referred to a larger bench.
I
don't know if it has been decided or not. Find out.
If I'm not wrong, my lord, Honorable Supreme Court has made it in pursuant to the judgment of Honorable Supreme Court. This amendment has been carried out, and that we have.
This. So we'll take up this matter next week. Just we want to, because that is the just give a chart about that date of decree in the family court,
Date of filing.
date of filing of the Mata here, and your date of marriage. These 3 dates just in a slip, and then we'll hear your argument on that. And so that Supreme Court decision which you are referring to. Because Family Court Act says it is 30 days. Hindu Marriage Act says it is 90 days. And your appeal, the Mata must have been under Section 19 of the Family Court Act. Have you verified it? Mata ro jo appeal memo, appeal memo ta jo file habo, Hindu Marriage Act ro general provision re hele apankar alga katha. Jodi gote Family Court Act matter ta dispose of karibo, ta against apon appeal karibe High Court. It would be under Section 19 of the Act, and that period is 30 days. So the question is that whether that 90 days would apply here or 30 days. If it would be 30 days, then obviously that has not been, this appeal has not been preferred with the time. But if it is 90 days, then perhaps that is perhaps you are arguing that matter. Upon marriage, so ये तीनटा date होची important. So that we examine.
Well, the edition is also saying that there's a matter has been referred to a larger bench by this honorable.
Just examine also that position also.
You asked Ms. Mahapatra, her matter had been referred. Whether there is a decision or not, that I'm not able to remember.
Yes, ma'am.
Miss Dipali
Mahapatra. Okay. So we are taking off on Monday or Tuesday, whatever.
My lord, item 25. Regarding the given an appointment under the rehabilitation assessment. My lord, at this matter, at length.
Want to withdraw this?
No.
So why are you mentioning? It is just rolling over. We are not taking off any matter out of list. Just,
I was not sure, तो मुझे पचास दिन.
condition of 30 दिन.
ଆସିଲେ 30 ଦିନ.
अच्छा.
ଆଉ 28 ରେ ଯୋଉଟା ଆସିବ ଅପିଲ ଯୋଉଟା କି ସବ୍ ଜଜ୍ ପାଖରେ ଫାଇଲ ହେଇକିରି ଆସୁଛି ଡିସି ଜଜ୍ ପାଖକୁ ତାକୁ 90 days.
ନାଇଁ 30 ଦିନ ଯେ ବଟ୍ ଡିସିସନ ଟା ପରେ ହେଇଛି ନା ତ ସେତେବେଳେ ଯାହା ଭଲ ହଉଥିଲା.
କେବେ ହେଲା ଡିସିସନ?
2024 ରେ ଦେଇଦେଲି ସେ ଡିସି ରେଫରେନ୍ସ ଟା ଦେଇଦେଲି. ଫୁଲ କୋର୍ଟ ରେ ହେଇଯାଇଛି.
କେବେ ହେଇଛି?
ଫୁଲ ବେଞ୍ଚ ରେ.
Matter came just we were asking my sister.
और मन पड़ला रेफर ହେଇଥିଲା ବୋଲି. So decision
ଜଷ୍ଟିସ ତାଳପତ୍ର ଯେତେବେଳେ ଚିଫ ଜଷ୍ଟିସ ହେଲେ ସେତେବେଳେ he was presiding over the full bench.
ପାର୍ଟିର ନାଁଟା କଣ ମନେ ଅଛି? ଡିସିସନ ମନେ ଅଛି?
Just give that if you have, or the reference you can just give.
Okay.
Yes.
Why seriously interim application for interim?
Please give it.
And the pardon to mention JCRL 137 by 2023, I have filed the I
for bail.
For bail.
Please give it.
No, I may be pardon to mention. Criminal Appeal 477 and 22. In that case, I have received a letter from the legal aid to move bail for the appellant because he has already more than 70 years.
Okay.
Therefore, I have filed the bail application that is IA number 575 of 23. ମାର୍ଚ୍ଚ ମାସ ଭିତରେ ସେ ଗୋଟେ କଣ ପିରିୟଡ ରଖିଛନ୍ତି. ନାଲସାର ଗୋଟେ ଆସିଛି ଗାଇଡଲାଇନ. ସେଇ ଅନୁସାରେ
yesterday I think a decision came of the Honorable Supreme Court that they need not file any application.
Without an application, it can be considered.
It can be considered. आगुर गोटे थिला जे application तमे दबो से they have to know that if you have formulated a scheme, then you are to apply it. See apply करू न करू से that is a different matter. That in that light they have stated like that.
ଏଇଟାରେ କିନ୍ତୁ ମୁଁ ଆଜ୍ଞା ଆପ୍ଲିକେସନ ଟା ଦେଇଛି।
No, it's all right. Yes.
ଦେଇ ଦଉଛି ରିସନ୍।
Supplemental list. Item number 1.
May I please, Your Lordship. The appellant convicted under section 302 and sentenced for imprisonment of life, fine of rupees 10, and in default undergo rigorous imprisonment for a period of 6 months.
What is your good name?
DK Dora. Dhiren Kumar Dora.
DK Dora. Admit call for the prior court report. Interim applications for the stay license account to be considered. The receipt of the prior court report. Supply the deposition copies to the state council. Yes.
Published, Your Lordship.
Item 2.
Yes, my lord. I received the letter of the surplus of the Sambalpur of the function GP and my lord, then I myself filed this affidavit, my lord, today.
Like that will ultimately be verified. We can accept it. See you, sir, Moriji, see you, the Pungota, you Moriji. See, some control the chicky load.
Thank you.
I will go to a collection for it. So, interim application is pending.
Yes, my lord.
What is the number?
Number
37 of 2025.
yes, that's my lord, prior to the incident, I have filed my.
No, it's all right. We know that.
ଇଏ କହିଲେ ମୁଁ ତାଙ୍କୁ 7 ଦିନ ଆଗରୁ ଭଲ କି ଜାଣିଛି।
ନା 7 ଦିନ ହେଲାଣି।
କଣ ହେଲାଣି? ଯାହା ଲେଖା ହେଇଛି ମୁଁ ପଢୁଛି ନା, ଯୋଉଟା ଲେଖା ହେଇନି କଣ ମୁଁ ସେଟା ପଢୁଛି?
11/2
ମୁଁ ପଢି ପଢି ଆସୁଛି ତଳକୁ ଯେ ଏହାକୁ ଆଜିକୁ 7 ଦିନ ହେଲା ହେବ ଭଲ ଭାବରେ ଜାଣେ। ତ ମରିଲାଣି।
Format.
Format because they say I know this person since so many days and this is what has happened. ତ ସେ 7 ଦିନ ଲେଖିଛନ୍ତି ଆଉ କଣ? ମାନେ ଯୋଉଦିନ ମଲେ ସେଇଦିନଠୁ ଜାଣିଛନ୍ତି ନା କଣ? ନା ଏଇଟା ଦେଖନ୍ତୁ obviously verified but ଇଏ କଣ ଲେଖିଲା କଣ? ସେ ମରିଲେ 11 ତାରିଖ ଦିନ ମୁଁ ତାଙ୍କୁ 7 ଦିନ ହେଲା ଜାଣେ।
ଏଇଟା obviously ଏଇ ଜିନିଷଟା 7 ଦିନ ହେଲା ଜାଣିଲି ବୋଲି ଏମିତି ଲେଖିବା କଥା। ସେ ଲେଖିଛନ୍ତି ଆଜି ତାକୁ ଏ ପିଟିସନ
ନାଇଁ ଯେ ମୁଁ ଏଇ ଲୋକକୁ 1 ଦିନ ହେଲା ଜାଣେ ଆଉ ଏଇଟା ଏଇଆ ହେଇଛି। ତ ସେ ଲେଖିଲେ 7 ଦିନ।
IA number
ସେ ଭାବିଛନ୍ତି relates to the incident.
IA number that is 37 na? 37 of 2025. This is an application for bail. During course of argument, the London Counsel for the petitioner produced the এটা কালি কিছু অর্ডার হয়েছিল কি?
direct file any document or
ସେ କଣ ଟିଭି ରେ ଆକ୍ରାନ୍ତ ହେଇଛନ୍ତି ଟିଭି। ହଉ ଏଠି ବ୍ରଣନ ମରିଛନ୍ତି 11 ତାରିଖ।
11
ଆଚ୍ଛା ତ ଭେରିଫାଇ କରିବେ ଆପଣ ଯାହା କହିଲେ।
Produce an affidavit with a certificate issued by
his own affidavit.
Achha, his own affidavit with the certificate of the sarpanch.
टीवी पेशेंट ଟା କଣ ମିଷ୍ଟର ମିଶ୍ର? टीवी पेशेंट
liver place
टीवी ସିଏ ସିନା ସରପଞ୍ଚ ସିନା ଲେଖିଲେ ଆପଣ ବି ଲେଖିବେ ସେଇଆ।
ସରି ସେଟା टीवी ହବାର ଭି ଲେଖା ଅଛି।
ଆରେ
in terms of the order dated also, file the affidavit of his own annexing the certificate issued by Sarpanch Sambalpur dated 18 to 2025 wherein it is mentioned that the son of the petitioner died on 11/2/2025. The affidavit along with the certificate taken on record. Learning counsel for the petitioner submitted that in order to perform the prosecution ceremony, the presence of the petitioner is necessary. And therefore, he may be released.
परफॉर्मेंस में पार्टिसिपेट करेंगे पर बता सारा को थे बना
हाँ,
आपको अच्छे करो
हाँ,
हाँ
sure.
चला 54 है तारा को अच्छे सो पार्टिसिपेट
In order to participate, so the presence of the petitioner is necessary. And he may be released on interim bail. Land counsel for the state has received a copy, the affidavit copy, so also the document of the Sarpanch submits that he has not obtained instruction on the same. Considering the submission made by the land counsel for the respective parties, the submission, the affidavit filed by the counsel, so also the certificate of the Sarpanch annexed thereto. We are inclined to release the petitioner on interim bail for a period of 2 weeks from the date of release, subject to verification by the learned trial court to the inspector in charge of
आर उदयगिरी
ଆପଣଙ୍କର କୋଉଠି
आर उदयगिरी पुलिस स्टेशन
to inspector in charge of R. Udayagiri police station about the death of the son of the petitioner on 11/2/2025. If the same is found to be correct, then only the judgment will be accepted. Tally is over application of substance problem. So, I to keep pending karibe and you will file the surrender certificate for consideration of the interim application. I put a total bail my file merit rate.
Okay.
Yes. And while on interim bail, you criminal it's now separate. So that is yes.
Item 3.
In item 3, my lord directed to produce the appellant to DC. Present my lord.
Counsel and
in this case, 616 days delay in filing the appeal. At the time of hearing, no counsel was present. But I have obtained instruction that the appellant was earlier before this honorable court in CRL number 377 of 2018, challenging the same.
Oh, then.
And in that case, the appeal already dismissed. The sentence was altered.
Conviction was altered to
counsel
304(1).
Part 1. ସେଥିପାଇଁ counsel ଆସିନାହାନ୍ତି। ଆସିଗଲି ଜଣେଇଦବା କଥା ଯେ ଭୁଲରେ ଫାଇଲ କରୁଛି ଏଇଟା ହେଇଛି ବୋଲି ଜମା ନ ଆସିଲେ କେମିତି ହବ? Appearance of the counsel. Unfortunate.
ଲୋକ ଅଛି ଟିକେ
ମାନେ ଇଏଟା ହେଇନଥିବ ବୋଧେ ସେଣ୍ଟେନ୍ସ ଟା ସରିନି ଜେଲର
ହେଲା ସେସନ ଜଜ୍ ନୂଆପଡ଼ା ଠିକ ST case number 74 of 2015 dated ହେଲା 3/4/2018 ଠିକ ଅଛି ଦେଖିଦିଅ
म्यूट ଅଛି ଅନମ୍ୟୁଟ
प्रशांत मेहर प्रशांत मेहर आमे जहाँ कहूँ आपण शुणी पार्टी आपण को जो जिला जज नुआपड़ा 3/4/2018 तारीख रे 302 दफारे आजीवन कारादंड देइथिले ସେଥିପାଇଁ ଆପଣ ଗୋଟେ ଅପିଲ ଫାଇଲ କରିଥିଲେ ପ୍ରଥମେ 2018 ମସିହାରେ, ଯାହାର ନମ୍ବର ହଉଛି CRLN ନମ୍ବର 377 ଅଫ 2018। ଆଉ ଏଇ କେସଟାର ଜଜମେଣ୍ଟ 6/4/2023 ରେ ହାଇକୋର୍ଟରେ ହେଇଗଲାଣି ଏବଂ ଆପଣଙ୍କର ଯୋଉ 302 କୁ କୋର୍ଟ ମାନ୍ୟବର କୋର୍ଟ ଏଠି 304 ପାର୍ଟ 1 ରେ ଆପଣଙ୍କର ଦଣ୍ଡ କରିଦେଇଛନ୍ତି, ଆଜୀବନ କାରାଦଣ୍ଡରୁ ଆପଣ କାଟି 10 ବର୍ଷ କରିଛନ୍ତି। ତ ଆପଣ ପୁଣି ଆଉ ଗୋଟେ କ୍ରିମିନାଲ ଅପିଲ 992 ଅଫ 2022 ଆପଣ ଫାଇଲ କରିଛନ୍ତି। ସେଇଥିପାଇଁ ଆପଣଙ୍କୁ ଡକା ହେଲା। ଆପଣ ଦୁଇଟା ଅପିଲ କଣ ପାଇଁ ଫାଇଲ କଲେ? ଗୋଟେ ଅପିଲ ଫାଇଲ କଲେ ଆପଣଙ୍କର ବିଚାର ପାଇଁ ରହିଥିଲା, ତା ଦେହରେ ଜଜମେଣ୍ଟ ହେଲାଣି 6/4/2023 ରୁ, ପୁଣି ଆଉ ଗୋଟେ କଣ ପାଇଁ ଫାଇଲ କଲେ? ଏବଂ ଭୁଲରେ ଲେଖନ୍ତୁ କଣ ଅର୍ଡର ପାସ୍ ହେଇଥିଲା କି ସତ? It is not after the judgment. In pursuance of the order dated 17/2/2025, the appellant Prashant Meher appeared through virtual mode from which jail? Ko jail? Bhavani Patna. From Bhavani Patna jail. We the London Council for the State brought to the notice of the court that against the judgment and order dated 3/4/2018 passed by the London Session Judge Nuapada in ST case number 74 of 2015 in convicting the appellant under section 302 of the IPC and sentencing him to undergo imprisonment for life and to pay a fine of rupees 20,000 in default to further undergo RI for 1 year. The appellant had earlier preferred CRLA number 377 of 2018, which has already been disposed of on 6/4/2023, and the conviction of the appellant under section 302 was under section 304 part 1 IPC, and he has been sentenced to undergo RI for 10 years and to pay fine of rupees 20,000 in default to undergo RI for a period of 1 year. The copy of the judgment passed in CRL number 377 of 2018 filed by the London Council for the State is taken on record. When we made a query to the appellant as to why, after filing CRLA number 377 of 2018, another this CRLA, that is CRLA number 992 of 2022, when the earlier CRLA was sub judice before this court. In reply, the appellant submitted that wrongly the appeal has been filed, and he begged apology for the same. However, we find that the London Council, who has filed the earlier appeal, is also the advocate for the appellant in the present appeal. The London Council is not present. let the Register Judicial serve a notice on the land advocate to appear before this court on 25th of February 2025. I would actually add for them too. In the post title, in the certificate portion of this criminal appeal, it has been mentioned. The matter out of which this criminal appeal arises was never before this court in this form as per the instruction received from the appellant. It was inverted comma bhitare.
ନାଇଁ ତାପରେ FIR match detail Agency of CRL 377
the table
same is not mentioned.
the details match for search criteria furnished by the registry indicates that the CRLA number 377 of 2018 was pending when this
Searched on and search was made on 9/11/2000
on 9/11/2022.
but the same is not mentioned
But
in the
the same is not mentioned in the
office notes.
Office note. The office note.
Section assistant, yes sir.
Office note.
ନା ନା FIR match details କାଢିକି ଖାଲି ରଖିଦେଲି ଯଦି ଅଫିସ ନୋଟ ଦେଲେ ତାକୁ ଦିଅନ୍ତି ଯୋଉଟା ପାଇଁ ପଳେଇ ଆସେ ସବୁ
No office note has been provided.
explanation ଟା
Submitted by the concerned officer as to why he has not mentioned in the office note regarding pendency of the earlier the pendency of CRL number 377 of 2018. The explanation be submitted in a sealed cover. And the file be placed before the Register Judicial for compliance. The personal appearance of Mr. The appellant is dispensed with. Yes.
ହଁ ମ୍ୟାଡାମ ପଳାନ୍ତୁ
ବନ୍ଦ କରି
Item 4.
item for my item for last order.
Notice on the victim matter. That letter was also issued to concerned IAC. Again, my lord, one letter was issued on that letter was issued on 12/11/2024. Again, on 22nd January 2025, letter was issued to furnish criminal antecedent and instruction regarding status of the victim, but no instruction received.
No, he is not responding.
My lord.
All right. Who is that IAC?
Ratho town police station.
ଆପଣ ଚିଠିଟା ଯାଇଛି ତ ଥରେ ଆପଣ ଅଫିସ ରଖିଦେଇଥାନ୍ତି
All right.
dispatch
Number
here.
ପଡିଛି.
The Mr.
Center
Naik, an additional government advocate, submits that as per the order dated 7/11/2024, notice was sent to the IAC Bhadrak
Bhadrap on.
नहीं नहीं भद्रक रे दीटा थाना আছে
Bhadrap
ଗୋଟେ rural town police station Bhadrak town police station for service of notice on the victim oblique informant
on 12/11/2024.
on 12/11/2024 है and since the information was not received on 12/12/2024 the no you sent the notice on
12/11/2024.
Since the information was not received when the matter was listed on 12/12/2024 the adjournment was sought for from the side of the state
ଆଉଥରେ ଚିଠି ଦେଇଛନ୍ତି ଆଉଥରେ ଚିଠି ଦେଇଛନ୍ତି
ଚିଠି ଦିଆହେଲା criminal antecedent ଆଉ status of victim.
And as per the order dated 21/1/2025 again later was issued to the concerned IAC on 22/1/2025 relating to furnishing about the status of the victim
and criminal antecedent.
So also criminal antecedent, if any, against the appellant. But there is no response to the letters issued from the AG office. Let the IAC Bhadrak Town Police Station appear through virtual mode. On 25th of February 2025 at 2 p.m. And apprise this court as to why he has not complied with the order of this court, which was communicated to him through the Land and Council for the state. And in the meantime, he shall comply the order and report compliance. Free copy of the order be handed over to the Land Council for the state. Yes. 25 तारीख रे रहला
Item 5.
Yes.
My lord, on behalf of Mr. Das, I'm seeking an adjournment.
IA for bail. What is your name?
Shreya Das.
Just like that. So and so appearing for Mr. Saugata Das, 6 for an adjournment. कितने दिन दरकार? 2 weeks. 2 weeks पर.
Item 6.
I have preferred this appeal against the judgment passed by the Lana District of Sambalpur on 13/2/2024.
Obtain the custody certificate and instruction about the criminal antecedent. You have obtained instruction about criminal antecedent. ସେ କଥା କହୁନାହାନ୍ତି ଦିଟାକ କହିଥିଲୁ ଦିଟାକ କିଛି ଆଣି ନାହାନ୍ତି 22/9/2024 ଜେଲ ଅଛନ୍ତି ଆଉ ପୁଣି କଣ 22/9/2024 ର ଇନଫର୍ମେସନ ଅଛି ଯେ नो କ୍ରିମିନାଲ ଆଣ୍ଟିସିଡେଣ୍ଟ ଆଉ ସେ ତ ଭିତରେ ଅଛନ୍ତି ଆଉ କଣ କରିବେ ହଁ କଷ୍ଟଡି ସାର୍ଟିଫିକେଟ with the council appearing what is your name Land and Council Surendra Mahanti Land Council appears through virtual High Court Sambalpur na Sambalpur the Land and Council for the state submits though he has received instruction regarding the criminal antecedent of the petitioner but he is yet to receive the custody certificate and the matter may be taken up next week कर दूँ List this matter on 25th February 2025. It will be on.
नहीं नहीं चिट्ठी ଯାଇଥିଲା 17/9 କୁ ଆଇଛି ଆଣିବା ପାଇଁ
It will be listed on 25th February, my lord. Here.
Item 7.
Appeal against the acquittal. Last session. Last session. Only there is no state appeal.
It's a informant's appeal against an order of acquittal. What was the offense? The
304B, 498,
498, 304B, अच्छा 4B clear.
You're supposed to obtain instructions.
No of state appeal. That instruction is there.
So
He consider his merit next.
Limitation is there.
So what is the error apparent on this judgment of acquittal?
Disbelieve the witness. Disbelieve the witness of the informant.
So he must have assigned the reasons why he has disbelieved. Because in the appeal against acquittal, the principle is well settled that even if we take another view, that cannot be a ground to interfere with the order of acquittal. It is an exceptional power which is to be utilized unless the material evidence has been overlooked or there has been palpable error apparent on the face of the record. Something inadmissible evidence has been taken into account for passing the order of acquittal. But if those things are not there on the proper acquisition, it has been done, then that cannot be a ground. So on what ground you are seeking for?
Ground assignment then only disbelieve but how the evidence of X was that one or two that he has taken into account that.
But in spite of that, your state is not preferring appeal.
That's why that is.
That is exactly so. If you say that no reason has been assigned as to why the important witnesses have been disbelieved by the London trial court, and it's a case of 498-304B. So, what is the cause of death?
Constriction on the neck. Constriction.
Ultimately, is it a homicidal death? That is the opinion of the doctor evidence who did a discussion.
6 months of marriage.
Doctor evidence who did discuss.
How nesty assume ready. Instruction pela goma accept karo.
अच्छा हो ठीक है. Land Council for the appellant seeks for an adjournment for preparation. This matter will be commencing from 3rd March 2025. Yes.
Item 8.
Mr. S.K.Sahoo. Nobody is there. Next case.
Item 9.
Item 9, my lord. Last evening, my lord, that the objection is to delay, my lord. Delay. I say some time.
Achha, it is 1253 days delay. What explanation you have given?
Explanation belongs to ST candidate.
ST candidate?
It's a wife, madam. Only nowhere is the village. Only wife is there.
No, it's a case where you are facing trial under section 302 and you must have been sentenced to life imprisonment. And during jail visit, the London district judge used to ensure that in all such cases, appeal are filed at right time. So that they used to check. So in spite of that, why you have Have you or you any other
Correct.
file any appeal?
Yes.
No.
What no?
One.
Appeal to 2022.
Your name is
Vichitra
Bania. You have filed another appeal, JCRL number 2 of 2022. Why are you saying no?
I haven't.
And it is pending also. এই যে তার রেকর্ডটাকে মগিয়ে কোন অর্ডার হয়েছিল কোন অলরাইট from the FIR details match for such criteria furnished by the registry, it appears that the petitioner has earlier filed jail criminal appeal number 2 of 2022 challenging the self-same judgment, self-same impugned judgment. Stop. Let the records of JCRLA number 2 of 2022 be placed out of this matter on 4th of 3rd, we commencing from 3rd of March 2025. In the meantime, the Land Council for the state shall file objection to the interim application, if any. That is IA2 interim application, that is IA number 13198 of 2024. All right.
Item 10.
This was issued to the informant last technology.
Sorry. What is the delay?
27 days.
27 days. Notice has been served. Please file the copy. The Land Council for the state has produced.
And the mother of the victim is
ঠিক আছে। The notice copy which has been served on the Indramani Singh ki mother of the victim, which is taken on record. ଆଜି ହେଲା କେତେ ତାରିଖ? 13 ସର୍ଭ ହେଇଛି, 7 ଦିନ ବି ହଉନି। ବାଇଚାନ୍ସ ଯଦି ଓକିଲ ହେରିକା ଦେଇଥିବ ସେ କଣ କରୁଥିବ, ଆଉ ତାକୁ ରଖିଦବ।
ତାଙ୍କୁ ଅପସନ ଦେଲେ ଥାନାରେ ଅପିୟର କରନ୍ତି ବି ଓକିଲ ଭାବରେ ଏନଗେଜ କରିବା ପାଇଁ ପଡିବନି। ପୋଲିସ ହାତରେ ଆମେ ନୋଟିସ ଦଉଛି, ଆଉ ଯଦି ଅପସନ ଦେଇଦବ ବୋଧେ ଦେଶକୁ ଦେଇଦବ ସେ ଥାନା କାମ ସାରନ୍ତା। ଏନଗେଜ କରିପାରୁନଥିଲେ ନା।
ଆମେ ତାଙ୍କୁ କହିଥିଲୁ ଯେ ଯଦି ବୋଧେ ଅର୍ଡର ହେଇଥିବ ଯେ ନାଇଁ ସେମିତି କିଛି ଅର୍ଡର What do you want, item 81? All right, and counsel for the Mr. Akshay Kumar Saul and counsel for the appellant is present, and counsel for the state 6 for an adjournment. This matter in the week commencing from 3rd March 2020.
I have already supplied the copy of depositions of the witness.
Acha, it is stated by the learned counsel for the appellant that he has supplied the deposition copies to the land counsel for the land counsel for the appellant's the deposition copy, the land counsel for the state in court.
तो पूर्व केस रे किए काउंसिल थिले जानि हला
द्विवेदी
हळे हो नाटा रखिथिले
एसएन द्विवेदी सुजे
ना सिए नथिले
और तांको जूनियर
सेटा तमे जानिचु पचरचु नाटा
सूर्यकांत द्विवेदी तो नथिले ना किए जाने
सत्य पचरचु बा वाई जे हम पचर दो
काउंसिल को ना पचार दें तो मेंशन कर
Item 12.
तो कुछ वेट पर लॉट करें
कहीं ना तो
can be taken up 2 weeks after the lodge. On behalf of Mr. Pal, your lordship, Mr. Pal is out of town.
What is your good name?
Your lordship, C. Mahapadra.
Huh?
C. Mahapadra. Chiranjeev Mahapadra.
So that since Mr. Jerry Pal and amicus curiae is out of station, then it will be taken up after 2 weeks. Put up this matter. That's the review. 10th of March 2020. Yes.
Item 13.
Notice, sir. All right, land counsel for the, who is for the
appellant,
Mr. Pritam Manji.
No, yes, those ones.
Is your the rules and corporate. It to the end.
ठीक है जो ना से अफेयर को जो ना थे
The land counsel for the state submits that compliance report regarding service of notice on the informant yet to be received, and the matter will be taken off up to 1 week. There is this matter. 10th of March 2025. Non appears for the appellant for the 10/3/2025. Arguably matter. Item. No, there was a partnered matter there. Your matter is part. Which is your item?
Item 15, madam.
Huh?
Mr. Officer will argue this. Okay.
Appeal was alerted to Mr. Pati.
Yes.
I will assist him.
So you are ready?
No, he has to be ready. You can assist him, but he has to be ready.
Officer will do.
You will argue, he will assist. So after ready बंदो.
Criminal appeal आपनको interest कराइची तो आपण argument करिवे से assist करि पारंती ना आपनको रहिबो तो आपण चाहिए